Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
LJ commentary on the case.
Is that correct?
I didn't ask you to interrupt me.
Alrighty, just trying to get everything working again. What are we going to take lunch, Judge? Your Honor, what are we going to take about lunch? What's funny is
that correct?
Mr. Farrak is still at lunch. He's still at lunch. He has not returned from that lunch, which just makes that funnier for me. And worse for him.
Don't miss the forest for the trees.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for being here today. Congratulations. Gina, Jacksonville, Florida. Hello, Gina. Welcome, Gina D. Good to have you here. A big welcome and shout out to our good friend and content warning, Adam Nusky. And he reminds me that I need to provide a little content warning for everybody. Guess what, guys? Today, here, and every day on this channel, we follow true crime.
Someone with more experience.
We'll do that as well. We follow true crime, which means we follow court cases that have accounts and depictions and sometimes videos of crimes in progress. That content is not produced by me, but we share that here with you for your educational purposes and for informational purposes.
I'm not a camel.
And if that offends you, then this may not be the show to watch. This may not be the show to watch for you. Okay, so just a heads up. We don't know exactly what's coming.
There's a lawsuit.
But yeah, lawsuits inbound, I'm sure. All right, I'm going to work that some version of that content warning into the intro. I might. It's been a year. You realize it's been a year that we've had that intro, and we might need to spruce it up. Maybe make a new one. What do you guys think? Are we ready for a new song, or do we use the same song and do a different video? Or some of you like, I hate that song. I hate that song. I love the intro. It's good. I have Deer Park water. I'm good. Hello to everyone who is not a camel. Becca, thank you very much. Welcome. This spout is broken. I went to drink and it just poured on my lap. But that is good water. That is good water. All right, here's where we are. We are still in a holding pattern, waiting per se. Chat not showing on screen. Why is chat not showing on screen? Give me a second. There we go. Chat's now showing on screen. Congratulations to Adam, content warning Nusky, who was first in chat today. Adam, with the profile picture that looks remarkably like red pens. Remarkably like red pens. Congratulations, Adam. You were first in chat. Repeat offender. Everything is Adam's fault now. Adam, we have gifted you.
For lunch, Judge.
We have gifted you the internet. Red pen just noticed. We've gifted Adam the internet. That means everything IP related is squarely on his shoulders. If it connects to the internet and it's not working, call Adam. If you just reach out to me on the burner phone, I'll give you his direct cell number. I believe that's how it works, Adam. And we'll make sure all the calls get routed to him directly. Adam, I would never do that. I would never. I show a bit more than red pen. Yes, you do. You got a bit more. Oh my goodness. Oh my goodness. Now I know where you got your. I just saw it. I mean, have you ever been looking at something for a long time and then realized what you were looking at? Yeah, that's what just happened, Adam. The red pen or this red pen. I'm not sure which one it is. I saw the fingers. That's the giveaway. I mean, I saw it when it happened, but I didn't realize that you had that Adam had grabbed that little screenshot for this moment. I thought he had just like taken it and used it as he would, but no, he captured the very moment. I just noticed. Can't see what it is, says Tisha. It's all right. It's one of those things you don't want to see. You don't want to see. Funny thought. Okay, let me share something with you. I'm trying to do this to get off this topic of conversation instead of pursue it. Have you guys ever seen this picture? It has 16 circles in it. I kid you not. There's 16 circles there. Do you guys see 16 circles? Somebody tagged me in that or something, or sent it to me. I was looking at it and like, well, first of all, you're a liar because there aren't. And then I saw them. I'm like, holy cow! Now I can't see anything but the 16 circles. But that's basically with a red pen situation. It's the red pen situation. Yes, Rudy saw it on Twitter yesterday on the X app. It looks like a garage door, something like that. But everyone's like, what? Put that back on screen. Let me, I don't know whose image this is. I'll see if I can, let me send it to myself and send it to the MacBook Pro. Go over here, see if I can put it up on screen. Okay. Show and Finder. What do we replace? We have a jail cell bars. We don't use that very often. Oh, my kid in a Halloween costume. Let's get rid of that for just a minute. Okay, here we go. I'm gonna show you now the image. It's on MP2. Ready? And we need to get this off there. 16 circles in there. No circles. Okay, by show of hands, how many of you can see the circles? Greener says, found it. I see it now. I see them. Nope, still don't see them. You have to look straight on to see it. Saw them right away. Anyway, that's neither here nor there. I can show you. Should I give it away? Should I give it away for those who are struggling? Okay, so look. Where's my mouse? Oh, I can't. So over there, if you look at the squares, there look to be like panels that get smaller and smaller with squares. Look at the space with the vertical lines between the panels, and the vertical lines make up a circle. Does that make sense? Just don't look at the rectangles. Whatever you do, don't look at the rectangles, right? They'll draw you in. Anyway, there you go. It's between the squares. And so don't look behind the red pen, I guess is the lesson we learn in this one. Don't try to look behind the red pen. All right. That said, let me see where we are in court. I don't know. How do we get here? Adam, this is your fault. I'm squarely blaming you for this one. You're the one who misappropriated even the logo. Okay. There we go. Hannah Payne. We're searching to see the latest. Okay. New update. Ready? This is through a commentator for Law and Crime. A new update. It's looking less likely. This is from Kathy Russin. Less likely they're going to have opening statements today. Still in jury selection. Where can I find that so I can keep looking? Right there. So here's the idea. Look, you've got the squares. The horizontal lines, ignore those. Only look at the lines that go up and down, and they get shorter and taller, and they make circles in the up and down section. There's like a circle between the square lines. That's how it works. Don't miss the forest for the trees. Okay. All right.
I'm not a
Having
cat.
someone
There you
with
go.
more
All right.
experience.
Adam, put it in your avatar. My eyes are definitely shot now. My apologies for that. My apologies. That was all my fault. Squarely blaming Adam. No circles. That's why. So here's our catch. We don't have the live stream we thought we were going to have yet. There's still a chance that they could proceed, but it looks like they've had to go on to at least one more batch of jurors. I haven't seen anyone who's given a count of how many have been seated or how many have been accepted, and so we're probably in the. It's probably close to 100 jurors, I'm guessing, that have been reviewed. Let's see, only 15 at a time. I was thinking 20. 30. We're probably still close to about 75 jurors that have been run through. Becca says, I'm the one who started it, not your fault. I was going to blame somebody. I thought Adam was convenient for that. Wait, were we all just subjected to some sort of mental testing? Yes, I've reprogrammed your brains, Donna, using a special. It's like a QR code, but it works for people. Parrot Court channel. RA did that to me. Adam just capitalized on it. Okay, Red Pen. In my defense, I think if Adam had widened out that shot and you could see the full message. Your message in chat was Recovery Addict, move the chat to cover the image so it's more appropriate. And I used your message to do that. And the red pen never occurred to me, the placement. I was just thinking this would be convenient, this would cover. And then of course, you guys all let me know what I had inadvertently done. So what are we going to do today? We can either go join Judge Boyd for her jury trial, see if we can catch up on what's happening with her. There's still some Louisiana board hearings that are going on. Let's see, who's this gun? Who's this one? Judge DeSanto. Okay, we have a police pursuit. Wasn't a good one. It just flees in reverse. He drove backwards. That's the highlight of the pursuit. Who else is there? Young Thug. Evictions. Evictions are no fun. Elijah McClain's a tough one to watch because the system's bad. Let's see. Judge Anna Garcia. Felony pretrials. Can play some video games. Oh, wait, no, we can't do that. Hold tight 1 second. I think Judge Boyd is at lunch right now. I'm just checking. I think if she when she comes back from lunch, we'll have a jury trial. But she's at lunch right now, so nothing there yet. Circles are a hoax. Gen B, they're there. You just have to. Imagine the circles consisting of a barcode. So they go up and down with a lot of little lines going vertical. That's where they are. Okay. Finally see the circles. Ceiling Stroop. Yeah, once you see them, you can't unsee them. We don't play video games or drink alcohol here. Yes, that's right. They're my kids' games. Adam hurt our brains prior to this. Adam, what did you do earlier? Is Adam abusing his internet ownership privileges? What would it be possible for you to cover the sentencing of Garth Pursehouse happening in LA tomorrow at noon? Brandy's going to cover that one. We're not going to be covering that one. So if I'm popping over to Brandy's channel would be the best way to do that. Brandy Churchwell is the channel on YouTube. He had the no E rule in chat. Have you banned letters? If you ban letters, please make it the B because I can't type that one anyway. Don't look at just the vertical lines between the panels. Also include the verticals in the panels. Adam's trying to censor us. All right, so we're gonna see if we can get a little bit of court here happening. There's still a chance that this one moves forward today. It's getting slimmer and slimmer as the day goes on. I'm being tagged, by the way. I'm being tagged in a bunch of Solomon Anderson, if you guys remember, the brother of Zachariah Anderson. We had him on the show. We interviewed him on the show, and it was a very interesting interview. I really was appreciative to him, especially that he came on knowing that where I stood on his brother's case. But there's apparently some new information out about egregious errors in testimony regarding the blood in the van. Interesting to see. I haven't seen the details on that. They say there's a letter of some sort. Let's see. Judge David Wolf, is that the one who you said was live? Tennessee. I'm not seeing his court going. I'm showing he was going an hour ago, but he's not live right now. Past live streams. He had a 3-hour trial. I did like his trial. We watched what trial was it we watched with him before? I think it was a not guilty verdict on that one. The lady was found not guilty. It was like a mailbox damage something. Can't remember all the details. But I do want to watch more of Judge Wolf. That would be interesting. Can't wait for Hump Day. If I win, I'm banning all Top Row buttons. My buttons? Like Top Row buttons? Or are you talking about like a shirt button up? Tanya, yes, my chin is cold. Chin is cold. All right, we're gonna see if we can find some content here that all of us have interest in. When did I shave? I shaved over the weekend. It was I believe Sunday morning, or maybe even actually I think it was late Saturday night. I shaved. Judge Stevens. I'm not seeing who you see. The Rittenhouse judge was the same judge as Anderson. Yes, with Mr. 9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
That was him. Now we're getting commentary on the case. Judge Schroeder, who I believe is retired. I think he's done now. Jenny and GA, so they've been in for 2 days and just noticed. Well, the reason is, Jenny, I keep the microphone where the goatee goes, and you also have like a little, so it mostly covers my face, and it's the same color. It's like white and gray. Let's see. Ooh, this is all right. I thought his kid was doing the live stream. Yes, it makes me look younger without the goatee. It's let's see. Do you have a budget recommendation for detecting the eastern Wyoming Black Hill area? Okay, first of all, you've got mineralized areas there. The problem with highly mineralized areas, it's good and bad. Good is you have all sorts of cool stuff in the ground in Wyoming. Wyoming is phenomenal, especially gemstones. But they're not, they're usually not found on a metal detector. But the problem you have with highly mineralized ground is that you end up having to spend a little bit more to get a nicer machine so it can really discriminate between the different signals, the good and the bad signals. So there I'd probably go for something high end. That Manticore is a good one, about $1,300 if you're really into the hobby and want to do that. My hubby thought you were bald because he only saw the headphones. Headphones come off. It's funny, at the end of the day, the hair around my ears, right there, I have like a headphone indentation around my ear, and I might like finish the day, and then my wife and I will go out to the store or something, and then we'll be shopping, we'll be talking to people, just having fun, going out, getting something to eat or something, and then I come home and I look in the mirror and I've got these like, it's like reverse of Princess Leia hairdo. It's where the hair all around my ears is pressed flat to my head. And she never said anything. Mrs. Ari didn't mention it to me at all. I have headphone hair. Need a case to get me hooked again. Fun and funky. We have a couple good cases coming up. We've got a few. Obviously, we've got Sarah Boone. We've been very interested in that. Is going to be coming up in January. We've got a hearing on the 16th. Trial date is on the 29th for the first day of jury trial. That's coming up. I know we've kept an eye on BK. That's probably more than a year out right now, maybe even 2. I mean, it's going to be a long time for that one to go to trial. We've got so BK is on the back burner. We also have Corey Richens. Corey Richens is crazy. It's crazy. This is the wag the dog, the letters, the fentanyl, the husband, the book, the children's book written for her kids about death and are you still with me, and just that one's going to be bizarre. So, my husband grew a beard in 1978 and has never shaved it off. Does he look like ZZ Top? That's got to be huge. Samantha, Sharon sent something in chat. I did see that one. We might pull that up here just for a bit if we're waiting for. Hang on one second. There's a couple. Sharon popped something in chat. Let's see, there's a couple things. There was one from earlier today. Not that one. Let me see if I can pull this one up. Just one second. We've got that Judge Kristen D. Simmons courtroom jury trial, but it's really poor video work. It's so bad. It would drive me nuts. I can't do that one. As much as it's a nice short, like a 4-hour trial, end to end, it would be awful to look at. Okay. Kalkaska County. Should we try Kalkaska County?
If there's any questions later on, I don't like to
Debating on that one. Hang on one second. Judge Clark. It's a felony trial.
the phones in the pod so that you can see who is currently using the phone.
I think we'll do this. Let's see if we can go to Judge Brantley Clark. Just one second here. Okay, we're going to have to back up to the previous one to get the beginning. Trying to find the open. Lots of nobody in court. Wait for the judge to arrive. I'm not sure if it goes straight to this or not. Okay, so let's go to 2.
Out. Let's let them in. And Mr. Cromartie, while they're doing that, I'm going to admonish you, you're not to turn around and speak to the people in the courtroom. You understand? That's a security concern, and so you can't do that anymore, okay? And I want them to be here for you, okay? And they need to be here for you.
Wasn't the jury present of his testimony that was just brought up?
Because, he may testify again, I don't know. The state made a proffer that testimony out of the jury's hearing to basically see what the witness would say. And that's the state's prerogative. The state has the burden of proving the case, so they have the burden of calling what witnesses they want to call.
I ain't stating that they ain't have the
Sir?
I'm not stating that they don't have the burden of proof to call whatever evidence they.
Yes, sir, they do. That's their prerogative.
What I was stating was
Is he pro se?
saying that he was brought in here to testify and the jury was not present.
Yes, sir, that was a proffer made outside. Ma'am, have a seat. Have a proffer outside the jury, and the state can do that. And the state has the burden of proof, so they can proffer the evidence.
That was
Okay, and like I say, I'm not going to argue with you about it.
It's not arguing. It's not arguing.
Yeah, yes, it is. I need to discuss some other things.
He's turning
And
around
to
looking
the
at him.
Mr. Cromartie's family, I want y'all to be in here. I want y'all to support Mr. Cromartie, but you cannot have discussions in the courtroom with Mr. Cromartie. You have to maintain proper courtroom decorum. If you don't, Mr. Cromartie has a right to an open, fair trial. It's not your right to be here. Now, I want you to be here supporting him, but if I have to, I can clear the courtroom. And I don't want to do that. I want y'all to be here. You cannot have discussions with him in the courtroom, okay? He can't turn around and speak with you. You can't speak with him, okay? Anything else we need to put on the record?
Yes, one other thing, Your Honor. Ms. Savoy, the witness that I spoke about earlier, is present in the courtroom, so
Okay.
I ask that she be excluded pursuant to the rule of sequestration.
And that's Mr. Cromartie's grandmother?
Correct.
Ma'am, you're going to be called as you're potentially a witness for the state, and the defense has invoked the rule, which means the witnesses can't remain in here while the other witnesses are testifying. No, ma'am, I'm not saying you're doing anything wrong. I'm just telling you, you're going to have to leave the courtroom. Okay.
She said, come in, I can't.
No, you're absolutely fine right now. I'm just telling you, you're going to have to leave the courtroom and wait until the state's case has been rested.
I understand.
Okay, very good. All right, anything else?
No, Your Honor. No, Your Honor.
All right, and Mr. Williams, what witness are you going to call next?
Yeah, fix the name. Oh, something went wrong. Did they pull it down already? Did they pull it down that quickly? Okay, give me 1 second. Okay, hold on 1 second. We're going to see what we can do
Anybody else?
here. Go up. Let's start right there. Oh, I think they had a problem with that feed. We're going to play catch up at 1.25 and back up to the beginning. Turned on, cut. There we go. Okay, so I think we're continuing that same thing. I think they had video issues that morning. This is today, so they're live right now. We're just a few minutes behind.
Jurors entering.
Oh, great. We get to see the jurors. 1, 2, 3, 4, 5, 6, 7. So 6 and 1. We have 6 plus an alternate.
Everyone have a seat. Let the record reflect all the jurors are back in their place. Mr. Sullivan, you may call your next witness.
Tom State calls Elizabeth Ritchie. My approach and gross and evidence, Your Honor.
Yes, you may.
So I think he's defending himself.
I get you to come up here and stand by the chair until it starts swearing anything.
Give the truth, the whole truth, nothing but the truth. I do.
If you'll have a seat, speaking to the microphone. Mr. Sullivan may inquire whenever you're ready.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
Could you please introduce yourself to the jury?
My name is Elizabeth Ritchie.
And Ms. Ritchie, where are you employed?
I work for the Florida Department of Law Enforcement in the Firearms section in the crime lab in Tallahassee.
And what do you do in the crime lab for the firearms section with FDLE?
My primary responsibility as an analyst is to compare fired components, so things like bullets, cartridge cases, or shot shells, to suspect firearms to see if those components may have been fired from a specific firearm. If no firearm is available, then my responsibility is to try to determine how many firearms may have been used in a scene, perhaps give investigators a potential list of firearms to look for.
And what type of education, training, maybe job experience do you have that allows you to do that job?
When I was promoted to the analyst position, first I had to have at least a bachelor's of science in some sort of laboratory science. I have a bachelor's in marine science from Jacksonville University. When I promoted, I went through FDLE's 18-month training program. Now, the first year is spent in book work, practical exercises, examinations. It covers the history of firearms, firearms function, ammunition, firearms identification. It included tours of firearms manufacturing facilities. And then I had a couple courses outside of FDLE as part of that first year. Once the first year was completed, the next 6 months was spent working supervised casework. That is where I worked actual cases under the direct supervision of a qualified analyst. Once the entire 18 months was completed, then I was free to begin working my own cases as a qualified analyst.
How long have you been a qualified analyst?
About 9.5 years now.
And in those 9.5 years, how many either firearms, bullet casings, or bullet projectiles would you say you have analyzed?
Thousands.
Do you undergo what is called proficiency testing as part of your job?
Yes, I do.
What is proficiency testing?
A proficiency test is a test that is provided to me. It's created by an outside organization known as Collective Testing Services. They create a test that would be similar to the kind of work that I do. So one year I may get a box with a set of known cartridge cases or bullets, and then 4 more boxes of either cartridge cases or bullets that are considered the unknowns. And I have to work that test as though it was an actual case. So I go through my entire examination. I report the results that I made to the CTS online platform, and then the results are sent to my supervisor, letting me know whether or not I passed that test.
How often do you undergo this testing?
Every year.
Have you ever testified in court as an expert before?
Yes, I have.
On how many occasions?
Approximately 100.
This time the state would tender the witness.
Mr. Williams, any questions?
No questions. I would ask that she be allowed to render an opinion.
She may render an opinion. You may proceed with the question.
Thank you, Judge. Ms. Ritchie, could you walk through, I guess let me back up and ask, were you asked to examine some items of evidence in this case?
Yes, I was.
And those items of evidence were collected by local law enforcement and sent to you for your scientific analysis?
That's correct.
How many items of evidence were you asked to analyze?
I received 4 items.
What were those 4 items?
I received 2 fired 40 Smith & Wesson caliber cartridge cases and 2 fired bullets.
Now, I want to talk a little bit about what you do and what you look for when you perform your analysis. So can you tell the jury what class characteristics are, individual characteristics, and how
We're court hopping while we wait for Hannah Payne's jury to be seated. They're not seated yet.
So let's start with cartridge cases. If I receive 2 cartridge cases that I'm asked to examine and no firearm, then I will open up the cartridge cases and I will do an inventory of those cartridge cases. I will look at class characteristics first. So those are characteristics that are predetermined by the manufacturer. An example would be the caliber. So in this case, 40 Smith & Wesson. Another example might be the shape of the firing pin or the firing pin aperture, which is the hole that the firing pin comes out of. Sometimes during firing, that shape will show up on the primer of a cartridge case. So what happens during firing when a cartridge is in a firearm is the firearm strikes the primer. When it strikes the primer, it leaves an indentation similar if you take a ball of Play-Doh and your finger and you stab that Play-Doh. If you look at that Play-Doh, you may see scars from your finger, the fingerprint you may have, maybe your nail impression. That kind of thing happens also with the firing pin striking the primer. So any defects that may be on that firing pin can transfer over to the primer. The other thing that is happening to the cartridge case is that as the bullet is passing down the barrel, the same gases that are pushing the bullet down the barrel are also pushing that cartridge case back against the breech face. Now, the breech face of the firearm is the bolt face or the face of the slide. It's the part that keeps the gun closed. It's where the cartridge case is resting against the back of the firearm. So again, any marks that may be on that breech face can also transfer onto the primer as it is slammed back against the breech face. So I'm looking at all of these characteristics, and if these class characteristics will match each other, then I will move on to an examination of individual characteristics. And individual characteristics are characteristics that would be unique to the firearm. So they're microscopic defects that are found on that breech face or found on the firing pin. And the way I do that is using my compound comparison microscope, which is 2 compound microscopes. They sit side by side. There's an optical bridge with 1 set of eyepieces. It's kind of like looking through binoculars, except I can look at 2 things at the same magnification at the same time, and I can compare what I'm seeing on side A to side B. So I start looking at the cartridge cases for the microscopic defects that may be found within the firing pin impression or that may be found on the breech face. And I start evaluating whether the information on cartridge case A is the same as the information on cartridge case B. Once I've done the examination of the individual characteristics based on what I see in my microscope, I will come to a conclusion whether or not I can determine if they were fired from the same firearm, maybe fired from 2 different firearms. Sometimes I can't make a determination one way or another whether or not they were fired in the same firearm.
And did you perform this explanation that you just gave on the items that you were provided in this case?
Yes, I did.
Approach, Your Honor.
May I approach?
Okay, so this is the state that's presenting this right here. I thought it was pro
what's
se.
been admitted into evidence as State's Exhibit 5.1, 5.2, and then 6.1 and 6.2. I want to start by talking about 5.1 and 5.2. Do you recognize those 2 items?
Yes, I do.
How do you recognize them?
When evidence comes in, it is immediately assigned an FDLE case number, item number, and it's marked with the FDLE barcode. So both of those things are on these items, as well as the I'm required to mark the packaging with the same information to include my initials, and all of that is present.
These 2 items, 5.1 and 5.2, are these the 2 shell casings that you examined?
Yes.
And were you able to ultimately make a determination or come to a conclusion regarding these 2 shell casings?
Yes.
And what was that conclusion?
They were identified to each other, and that means that it's my opinion they were fired from the same firearm.
Do you have any other testimony as to these cartridge casings and what you were able to conclude about them?
These cartridge cases display class characteristics consistent with some firearms by Smith & Wesson, specifically the Sigma series firearms.
If you could switch over to State's Exhibit 6.1, 6.2.
Jen, welcome back. Good to have you on the jury. Thank you so much.
Yes,
Appreciate
I do.
Your support.
How do you recognize them the same way as the cartridges?
Yes.
Were you able to come to a conclusion about these 2 exhibits?
Yes.
First, these 2 exhibits, 6.1, 6.2, these are 2 projectiles, correct?
That's correct.
What conclusion were you able to come to about the 2 projectiles?
It was my opinion that they were fired from the same firearm.
Were you able to determine the caliber of these 2 projectiles?
Yes, they are either 40 or 10 millimeter caliber class bullets. Caliber class is based on the diameter of the bullet. So it's a family of calibers. 40 Smith & Wesson would be one of those calibers. 10 millimeter auto would be one of those calibers within that caliber class family. And it's based strictly on the diameter of those bullets.
So these bullets meet the caliber of the shell casings?
Yes, they're consistent with each other.
Now, you were not provided a firearm in this case, correct?
That's correct.
So you have no way of determining which gun these projectiles and casings were fired at?
That's correct.
Just that they were fired from the same firearm?
The cartridge cases were fired from the same firearm and the bullets were fired from the same firearm. I can't tell you if they were all 4 fired from the same firearm.
But they're consistent with being potentially those 2 projectiles fired from out of those 2 cartridges.
Potentially.
We got no further questions, John.
Williams? No questions. Can the witness be excused?
Yes, Your Honor.
Ma'am, you may go about your day.
Thank you.
Now
You
it's
may
time
go
to call
about your
Warren
day.
Jacobs. If I may approach to gather that evidence.
We are at 1.25 speed as we're like 20 minutes behind on this trial. And he has been having some trouble with his live stream going up and down today. But this is happening live. I think we're about 10 or 12 minutes behind live right now. Apparently the defendant has been having conversations with people in the gallery, and the judge is saying none of that. So we got that earlier, saying you can't turn around and talk to him. You got to look forward. But we also get to see the jury as they walk in and out of the courtroom, which is sort of fun.
Can you come up here, stand by the chair until the clerk swears in, please?
All right, ma'am, you have a seat. You're speaking to the microphone. Mr. Sullivan, you may inquire whenever you're ready.
Thank you, Your Honor. Good morning, ma'am.
Morning.
Can you please introduce yourself to the jury?
My name is Lauren Jacobs.
Ms. Jacobs, did you know a gentleman by the name of Angel Santos?
Yes, I do.
How did you know him?
He's my friend.
How long have you known him?
Probably 13 years.
What about Jamel Kamari?
I've met him a couple of times.
Did you know him as Mello?
Yes.
Are you aware, back in 2019, where Mr. Santos was, I guess, let me rephrase that question. Are you aware of where Mr. Kamari was living back in 2019?
Yes.
Do you know what that address was?
Off Bird.
Bird Drive?
Yes.
You're not sure what the numbers were?
Yeah, not sure.
I want to take you to the day of July 14th, 2019. Would have been the day prior to that night where Angel was shot. Are you aware of that time frame?
Yes.
Did you drop Angel off anywhere on that day on the 14th?
Yes, over on Bird Drive.
At Mello's house?
Yes.
And what was your understanding of why you were taking Angel over there?
So that he could spend the night over there.
Ms. Jacobs, if you could, there's a book there in front of you. If you could flip to 3, the number 3 there, and look at what's been admitted evidence as states exhibit 3.1.
A random book in front of
It
you.
should be a photograph of a gentleman laying in the hospital. Do you recognize that person?
Yes, that's Angel Santos.
Is that the person you dropped off at Jamel Kamari's house on July 14th?
Yes.
No further questions, Judge.
Williams, any questions?
No questions, Your Honor.
Can Ms. Jacobs be excused?
Yes, Your Honor.
All right, ma'am, you may go about your day.
Thank you.
Miss Nike
At
there.
this time, the state would call Lenora Savoy.
Very little she needed to testify to. No questions from the defense on 2 consecutive witnesses now. I do apologize to all those who are asking questions about what is this. This is a random trial we're watching while we wait for the Hannah jury to be seated. This is just Judge Wolf's courtroom out of Florida. We're in Bay County, Florida. We know this is a felony trial, and that's about it. That's about it. So anything we pick up along the way, we'll go ahead and pass on to you. But Judge Clark has a huge personality, and so we like.
Can you stand by the chair, please? Until the clerk swears in.
Please don't swear or testimony shall give truth, the whole truth, nothing but the truth, so God. Yes.
All right, ma'am, if you have a seat and speaking to the microphone.
Ooh, she brought her big bag of
Mr. Sullivan, you may
tricks.
inquire whenever you're ready.
Morning, man. Good afternoon, man. Can you please introduce yourself to the jury?
Evening.
My name is
She corrects it.
Lindora Savoy.
And Ms. Savoy, my understanding is you are Mr. Kamari's grandmother, correct?
Yes, I am.
And when this all happened back in July of 2019, you were the person who took Mr. Kamari to the sheriff's office on July 15th, correct?
Yes, I am.
And you were ultimately asked some questions and gave a statement to law enforcement on that date.
I gave a statement,
And
but my statement was limited.
yes, ma'am. And I've just got 1 or 2 questions about that statement. You were asked about when Mr. Kamari, your grandson, arrived at your house earlier that day, correct?
I was told when he arrived, but when he arrived, I brought him to my residence on Sunday evening. Can y'all hear me?
Yes, ma'am, I can hear you. That is not what you told law enforcement, is it?
I told them, the officer told me I couldn't say that. That was Gerald Turner.
May I approach, Your Honor?
You
approach. Ma'am, I'm showing you a copy of your statement to law enforcement.
It's limited.
And if you could look at that.
It's limited. The officer
In that
told me I
statement-
could not say that.
You swore to tell the truth, did you not?
Yes, and I'm going to tell the whole truth and not the limited truth. I brought him to my house
Mr.
Hold on,
Boyd,
on Sunday
hold on,
evening.
let me see this, let me see this, please.
Mr. Boyd, I'm gonna direct you to answer the questions as they're posed to you, okay?
Mhm.
You were asked by law enforcement. So earlier this morning, your grandson Jermel came over to the house. Is that correct? You remember being asked that question?
I don't think it was understood.
That's not the question I'm asking, ma'am. Do you remember being asked the question, did Jermel, your grandson, come over to the house earlier this morning?
I don't know what.
It's a yes or no question.
I don't know exactly what I said.
Well, if I show you.
Wow. Okay, I'm gonna slow this down just a little bit because it's getting good already. We're only a few minutes behind, so let's change this back to normal speed so we can hear in all its amazing.
You're asked, did your grandson come over earlier this morning? And your answer was, mm-hmm. Correct?
Mm-hmm.
That's what it says.
And then law enforcement continued to ask you what time? And your answer is between 6:30 and 7:30 in the morning.
Mm-hmm. That's the time that's here.
Okay. And then later on, and you can look through that statement, you're asked if he said where he was coming from. And you told law enforcement that he was coming from his cousin Mondo's house.
Yeah, which was next door.
Okay. And that was in the morning of the 15th.
That was in the morning of the 15th.
I've got no further questions, Your Honor.
Mr. Williams, any questions?
No, Your Honor.
Can Mr. Boyd be excused?
Yes, Your Honor, if I may approach the guy.
Yeah.
No
Mr. Boyd?
questions?
Yes, sir.
You're excused from the rule. If you'd like to stay in the courtroom, you may stay in the courtroom now.
I need to tell the whole truth.
Ma'am, if I could have that, please.
She wants to.
Yeah, I can't have it.
Yeah, you can have it. I don't. Yeah.
Mr. Boyd, you have a seat, please.
Can I keep this
I
evidence?
need to tell the
No,
whole
ma'am, Mr. Boyd, there's no questions before you. You've been excused. If you'd like to have a seat in the courtroom.
I'm not sure if there's any pro se in here. This is crazy. She clearly wants to say something differently. No questions from the defense. Three witnesses in a row.
So you may call your next witness.
Around this time, the state would call Brian Tyler.
He could have asked her, what did he want to share? Now, I don't know what his theory of defense is, and maybe it just doesn't fit with what she wanted to share, but no questions for three consecutive witnesses. One of them being, seems quite connected with the case of the woman who brought him to the police department. And she's in her statement is alleging that the police directed her what to say, and there's no cross-examination on that.
If you come up here, stand by the chair so the officer, please.
From the testimony you shall give the truth, the whole truth, and nothing but the truth.
Yes, ma'am, I do. So you need to have a seat. Speaking to the microphone. Some you may inquire whenever you're ready.
Thank you, Judge. Good afternoon, sir.
Good afternoon.
Can you please introduce yourself to the jury?
Brian Tyler.
And where are you employed?
Employed at the Bay County Jail.
What do you do for the Bay County Jail?
I'm the chief of security. I manage everything inside of the housing areas and in between.
I want to talk a little bit about the phone system at the jail. Are you familiar with the jail phone system?
Yes, sir, I am, intimately.
Could you explain to the jury how that works, how inmates are allowed to make phone calls?
Inmates are assigned a PIN number upon entry. Its PIN number is unique to them. It's usually a 4-digit number. They also have a secondary line. It's a voice recognition. All inmates have to repeat a key phrase whenever they get on the phone. I think it's like with GTL, my voice is my password. The phone picks up on their specific voice and allows the call to connect, or they can dial the number.
Is it
with GTL?
Your experience,
my voice is my password.
Let me ask, how long have you been at the Bay County Jail with security?
Almost 5 years.
And in your experience,
with GTL, my voice is my password.
Inmates to use other inmates' pins to make phone calls?
Yes, sir, all the time.
Do you have cameras at the jail that show where these phones are?
Yes, sir, I do.
And you're able to see who is making phone calls.
Yes, sir.
On those cameras. If you could look at that book in front of you.
My PIN is 0.
What is the pre-marked for identification?
00.
Yes, sir.
You recognize that?
Yes, sir. That's a copy of the jail phone call. Oh, I'm sorry. I'm on 16. 15. I apologize. 15. That's a copy of the jail video.
And you've watched that video?
I have, yes, sir.
What does that video depict?
That is a camera from inside of one of the pods of a dormitory that it actually shines in two different directions, but the one camera covers the phones in the pod so that you can see who is currently using the phone.
And what is the importance of that particular video?
This particular video verifies that the phone call in question was in fact made. We could visually verify that it was made by Mr. Cromartie.
So we're gonna get to the phone call in a second. Ultimately, we'll talk about that in detail in a second. But ultimately, you found a phone call where Mr. Cromartie made a phone call from the jail.
Yes, sir.
And talked to Mr. Santos.
Yes, sir.
And after you found that phone call, you went back, pulled the video surveillance.
Yes, sir.
And confirmed that it was Mr. Cromartie actually using the phone.
I did, yes, sir.
Why did you do that?
Again, to verify, number one, that it was Mr. Cromartie using the phone. The call was made from another inmate's PIN number. So again, this is for visual verification that Mr. Cromartie was in fact on the phone and made that phone call.
And the timing of this phone call and this video line up?
Yes, sir. Perfectly.
Your Honor, this time the state would move State's Exhibit 15 into evidence.
Any objection?
No, Your Honor.
State's Exhibit 15 will be accepted into evidence. You may publish whenever you're ready.
Madam Clerk, if I could have the screens, please.
Give us the screens. Give us the screens. Oh, here we. Oh, I need to move, guys. Sorry. There we go.
Before I hit play, what are we looking at here?
So this is the back end of the pod. A1, which is the first pod of a dormitory. It's basically a mirror image for 2, and then 3 and 4 are also pretty much identical.
And
these are the phones down here at the base of the screen. You'll see 3. Actually, you'll see the very tip of the 4th one, which can be seen from another camera angle. But there's 4 phones. Those are pedestrian phones. Basically, you walk up to them and use them.
And there are 3 gentlemen kind of at those phones in that bottom corner. Which one is Mr. Cromartie?
He would be the one in the middle of the 3 that you see.
So how long is this video?
I'm not playing. Just a short clip on it.
Okay. We have to jurors that need a break, a bathroom break. You want to go ahead and take it now, or how long?
The jurors just
yes,
came in.
because I plan on playing the jail call after. Okay, so that's
we'll
fine.
go ahead and take a 10-minute break. I'll give you a chance to bathroom. So we'll start back at 10 after 2. Remember to leave your notepads in the courtroom. Do not discuss the case amongst yourselves or use any electronic sources to find out any more about the case than you know right now, or any media sources.
Okay, so jurors are going to get up and walk out of the courtroom. You're going to see them here. Notepads down. They've been sitting here for maybe 10 minutes, and they're like, oh, witness stands up. That's nice. And they need a bathroom break. Oh, it's that guy. You can see he's walking a little funny. Yep. He's like, oh, it's me. Guys, hurry, hurry, hurry. Open the door, open the door. They just started. But
all right, everyone can have a seat.
Stress of court. Things happen. Time for a break.
If anybody else needs to take a break, Marty, do you need a break right now? Okay. Anybody else needs a break? We'll be in recess for 10 minutes.
10-minute recess. So we're going to go back and find that one when it restarts.
Decided that under the circumstances.
I don't want that. I don't want that. All right. Although I like Judge Darrow. She's amazing. So where are we? Judge Clark. Go to channel. Hang on, too. I think we're live right now. I think we're back.
I'm not going to go and play. I'm going to take. And I'm not going to just take one. I'm going.
Okay, so I will give you a warning here. We're back because remember, we were getting a little bit behind.
Continue with your direct.
Thank you, Your Honor.
Give you a warning. You might hear language on this.
Out of these 3 gentlemen at the bottom, which one is Mr. Cromartie?
That would be the one in the middle, sir.
And as I play this, I want to kind of have you describe to the jury what we're seeing happen.
So the other gentleman that's coming up to the phone right here that he just took
says,
he's
with
going to use
GTE,
his
my
PIN
voice is
number
my password. With
and his
GTE, my voice is my
authorization,
password.
voice verification, I was telling you, in order to allow Mr. Camardi to dial the number.
They're kind of looking as
Right.
they're doing this.
Obviously, you don't want staff walking up on you while you're violating rules, so you're gonna have a lookout man. In this particular case, the one that's entering the PIN is facing the officer station. Make sure that nobody's coming that way.
So I believe this is Mr. Chavez is putting in his PIN, giving his voice activation.
Oh, sorry,
Right.
I'm not showing you.
You can
guys
actually see him mouth it right before he cups the phone.
And then he hands the phone back to Mr. Camardi.
Yes.
That was
This
embarrassing.
video goes on and shows Mr. Camardi on the phone for several minutes.
It does.
And I think you testified that you had already located the call and found this video as verification.
Yes, sir. That's exactly right.
If you could turn to that book, what's the pre-marked identification states is at 16.
I'll be up here.
Yes, sir.
Is that the jail call that we're referring to?
It is, yes.
And you listened to that? You listened to that?
Yes, sir. Yes, sir.
And you recognize Mr. Camardi as being the person on that call?
Yes.
Yes, sir. This time the state moves states exhibit 16 into evidence.
Any objection?
No, Your Honor.
State's exhibit 16 will come into evidence. You may publish whenever you're ready.
Okay, so now you guys can see, right? So now I'll go full screen so I can watch as they browse through somebody's computer contents. Looking for the file. Let's open that one. Is this the right one? Yep. That's not VLC. That looks like Winamp.
Oh. I have transcripts for this one as well.
Whoop! I accidentally played the latest GTA trailer instead of the actual file. So let's move that over. I think the GTA trailer dropped
Ladies and
yesterday.
gentlemen, you're about to hear recorded conversations. These recorded conversations are proper evidence, and you may consider them just as any other evidence. You're also being furnished transcripts of the recorded conversation. The recordings or the evidence and transcripts are provided to you only as a guide to help you follow as you listen to the recordings. The transcripts are not evidence of what was actually said or who said it. If you notice any difference between what you hear on the recordings and what you read in the transcripts, you must rely on what you hear, not what you read.
So the transcripts are like a version of
And
bad lip
Chief Charlie,
reading.
before I hit play, at the beginning of this call, there's kind of like an automated message that's given.
Yes, sir.
And it informs the calling party, the inmate, and the person being called that the call is being recorded.
Yes, sir.
Is that given for every call that's made from the jail?
That is standard for every single call made from the jail, with the exception of those to attorneys that are privileged.
Attorney and clients, they're not recorded.
They are not recorded.
You are receiving a prepaid call from
TJ.
an inmate in
Bay County Jail.
your balance is 20.8 cents. This call and your location are recorded and subject to monitoring. Call accepted.
Hello. 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 I called you too early. I'm still in the same spot. Is you good? Alright. What's the phone at you?
All right, hold on. Let me get in the room so it's quiet.
Thank you. It's gonna be quieter here.
I think I lost some $10 you gave me.
Huh?
You gave me a $5. God damn, y'all be taxing. Y'all just be taxing a bitch. I can charge it right here. What's the money?
What they doing?
Huh?
What the hell they taxing?
For who the? This $10 for different G's. Shit.
Huh?
That $10 a pound.
Oh.
Hell yeah, some guys. God damn. They ripping their stuff off with the bullshit.
Shit, they paying for it.
Yeah.
So it's fucking.
That's her number.
Alright. Oh, she pick up. It's not he pick up.
Hold on.
This is so bad.
Hello. Hey.
So, cabrón. What's up, brother? What's up, man? You going good? So you going rat on me? Oh, I still don't even know why you shot me, bro. Cabrón. I ain't do that, man. We ain't even talking like that over there. You know what happened. You know what I mean? So listen, that's what you gonna tell the peoples? I mean, listen, bro. I'm listening, Your girl called me. Your girl called me and she talked about something, and I told her if they come through, she got my word. All right, I hear what you're saying though, bro. Listen though, man. All of it was just, you know what I'm saying? My mind, I don't know what my mind was at. But listen, I ain't had nothing to go do nothing with that. You feel me? But at the same time, man, you telling them people that I had something to do with it though, bro? Bro, I never said anything. You want to know what? Whenever I ain't keep it real G for though, man. Like for real, man. Listen, bro. Whenever I ended up in that ditch, I woke up 4 hours later and I dragged myself to the road. And white boy found me out there pretty much dead. And he said, "What happened?" I said, "He shot me." He said, "Who?" Yeah. And he called 911. Bro, listen. I understand. I read that, bro. But listen, that's real, though, bro. I feel you, though, bro. If anything, if you feel like it's me, bro, I apologize. You know what I'm saying? Bro. You feel me? But listen, bro, call them people, bro, tomorrow or whatever case may be, bro, and tell them people I ain't had nothing to do with that, bro. They trying to give me life, bro. You know what? That shit that happened, it stopped my life, man. I was in bed for 4 months. I was in a coma for 23 days, man. I left my job. I left my girlfriend. I'm sorry. I feel sorry for you. I really do, bro. I send my prayers out to you. You know. And listen, you know what it is for me to not be able to work for the last 8 months, bro. No type of money for 8 months and fucking laying in the bed. I know it's straightening your life out.
It was good for you.
Tell your peoples to do what they say they were gonna do, man. And you got my word. You know I always told you. Say what? That if I'm gonna do something, I do it. Say that again. Tell your girl to run what she said she was gonna run. Tell your people to run what they said they were gonna run. And if they don't have it, that's what you gonna do then, huh? Well, I mean, you know they got it. Say what? You know they got it. I can't hear you. What you say? I say you know they got it. You know they got what? As in what? Whatever she said she was gonna do, you know she got it. The people's got it, man. I understand. That's all I want. I understand what you're saying. If they don't have it right now, I understand. But if they don't have it, what you telling me that you gonna pursue that shit? I can't. They're not. Bro. I mean, you gotta see where I'm coming from. I hear what you're saying. There weren't even no reason for that shit to go down how it went down, bro. Hey, you know exactly what's going. Hey, you right. But listen, I ain't had nothing to do with that. You know what I'm saying? But listen, you know, man, bro.
So if you didn't have nothing to do with that, bro, who did it?
Bro, I can't say nothing over this phone, bro.
See what I mean? You with the bullshit right now with me, bro. And you and me both know. You and me both know what happened that day.
Hey, listen,
listen, bro. If somebody, listen what I'm gonna say. If somebody sent you to do what you did, you need to tell me.
But listen to what I'm.
You get what I'm saying? I listen, man, bro. You know they already tried to kill me once, and this second time it was too much, bro. I'm not. Unless they talk to me about what they say they were gonna do, I'm not gonna back out. I mean,
so what
you know what you gotta do, man.
Okay, so listen.
Yeah, bro. Listen, bro. I was in the hospital for 23 days on country, bro. I was plugged up to fucking life support for 23 days.
Listen here, I understand that, and you know what? You know what's going on. You know exactly what you said and what you had. You know what I'm saying, going on beforehand and all that. You feel what I'm saying?
Yeah.
You feel what I'm saying? But it never turned on you like that. Now you're trying to turn on me like that, and let these people have me, and hold on, and let these people have me. Come on, what kind of real G shit? What kind of life is that, bro?
You need to be clear about the shit. If somebody, bro, if you roll with me and you real G like you say, cause I'm real G. You need to tell me who fucking said.
If you real G, no real G, go to no state's attorney or whatever case it is. And tell.
No, see, I never dealt with them, bro. They brought me to the hospital dead, and they took care of everything while I was dead, bro. I was dead.
Well, then listen to what I'm saying, though. Listen here. Listen. So therefore, what they talking about saying that you gonna sit up here and testify on me?
That's what they saying.
So that's what that's what they saying. But are you?
You come up with your part of the deal with me, bro. And you got my word, man.
Okay, well then, what?
You stop, bro. You stop. You stop. You stop my life.
Huh?
You stopped my life, dog. You stopped my life for 8 fucking months.
I ain't had nothing to do. Listen. All right, they give you a band straight up, right? You know what I'm saying? You still ain't gonna say nothing, and then I give you the other band when I get out.
When they gonna send the money?
Bro, whenever they get it, bro, they got to know you for sure, bro, because you got to send word to them people to let them people know for sure that I ain't had nothing to do with that.
Bro, I'm giving you my word. If your people come through, you got my word on it.
Bro, you know how many times you know how many times you gave me your word and your word what didn't mean shit, bro. You know how many, bro, I looked out for you for a long time, bro.
That's not true, bro. Same, I mean, I did a bunch of stuff for you too, bro. You know when I had it.
Hold on, no, come on, let's be for real now. When you had it, you ain't never, listen, I ain't never had to come to you like that. If you did, and I don't remember you do, but we ain't gonna get in that. You know exactly what the truth is, bro. We on the phone, bro. Now be for real, bro. Be for real, man. We real up, we being straight up.
I'm being for real. I'm being for real, bro. Whenever the fuck I was going in Puerto Rico, who was making it happen for you?
You didn't do nothing for me when I don't want to kind of pick you up though, bro. But I appreciate you saying that though. You know what I'm saying? I appreciate you saying that.
I mean, I gotta say it. I gotta say it because it's the truth, bro. You forgot about all the shit I put in your hands while I was gone.
Bro, only thing you put, if that's the case, bro, if you put anything in my hand, bro, we squeeze that out of candle. We squeeze that out of candle. That's the only thing you had, and that was even 100.
Here's the thing, man. Listen, This shit that happened stopped my life for 8 months, bro. I lost my girl, I lost my job. I can't even talk to my son, bro. You know I got a son, bro, and you let this shit happen.
Well, listen what you
know.
Listen to what
You know my son, dog.
You're gonna get your end of the bargain. You feel me? And once you do, just go ahead and keep it real and just keep the shit silent. Keep it silent. You real deep for life.
All right, well then tell your peoples to work with me, dog, because they don't fucking trust me.
Well then listen to what you're doing and listen to what you're saying. Your own peoples don't even trust you right now.
Nah, that's not true. I'm just because my baby mama fucking don't want to fucking let me see my son.
I ain't even just talking about your baby mama, bro. I'm talking about your peoples, bro.
What people?
Bro, I ain't gonna say too much over this phone, but man, and then the shit with Maggie, Maggie, whoever was, you know what I'm talking about with the hotel shit, bro. There's a lot going on with you, bro.
I mean, listen, bro.
See what I'm saying? You gotta let me know that you're gonna be 100 on your end to free me, dog.
Well, I want you to tell me the truth, then, Mello.
I'm telling you the truth.
All right, so
you gotta let me know.
The tail and all that.
You listen here. Listen here. You gonna have that, bro. And the thing about it, if you get you get a ban or whatever first quarter, but you gotta let words be said that ain't had nothing to do with that. And the prosecutor and the state's attorney got to hear you, or they got to get a note from you, and you get the other half, bro. You can't just play me like that, cabrón. You know one thing about it on 100, and
I ain't gonna do that shit. You say you're gonna do it. Let's do it then.
Okay then. So you say you're not gonna do what?
I mean, we really gonna talk about it on the phone, bro?
Oh, okay.
You know what we talking about.
You got your word then. I got your word. If you ain't gonna sit up and let these people have me, then I understand that.
Don't want to say it on the phone.
Then just talk to your people. Talk to your people. Tell them you talk to me. But you know, more than that, Mano. More than that. I want the truth to be told. I want you to tell me what the fuck happened. Who's behind it?
Let me do that when I get out.
Melo. Who's behind it, Melo?
Let me tell you when I get out. I'll let you know if you.
You have 60
bro, because you want to know what, Melo?
Melo. I can't do that.
Melo, if there's any Melo, if there's somebody behind this shit that happened to me, Melo, I'm gonna fucking take. I'm gonna take, and I'm not gonna complain. I'm gonna take, and I'm not gonna just take one. I'm gonna take everybody.
Oh, and you're not wrong. You feel what I'm saying? So let me get a chance, free my life, and I'll let you know, and I'll help you out.
You have 30 seconds.
Well,
free my life, and I'll help you out. You got my word. You got my word, bro.
Get everything squared up, and when y'all get it squared up, give me a call and have it on my hands, and you got my word, man.
All right, say no more, man. Take care of yourself, man. Love.
All right.
Yeah, I didn't hear anything inappropriate in that call at all. It was just a couple bros sharing some talk about good old times.
Williams?
No questions, Your Honor.
Can the chief be excused?
Yes, Your Honor.
Sir, you may go about your day.
No questions on defense.
No, I've got no more witnesses to call, but before I rest my case, I would like to publish previously entered State's Exhibit 17.
All right, you may publish.
And one last time, Your Honor, I've got transcripts.
Oh, and we have the transcripts. Okay, we're going to watch a video. I'm going to move up the top again.
Ladies and gentlemen, you're about to hear recorded conversations. These recorded conversations are proper evidence, and you may consider them just as any other evidence. You're also being furnished transcripts of the recorded conversation. These recordings are the evidence, and the transcripts are provided to you only as a guide to help you follow as you listen to the recordings. The transcripts are not evidence of what was actually said or who said it. If you notice any difference between what you hear on the recordings and what you read in the transcript, you must rely on what you hear, not what you read. You may publish.
Thank you.
The following statement is being conducted by Investigator Hakey of the Pickens County Sheriff's Office. This interview is being conducted over the phone. Today's date is February 27th, 2020. The current time is 11:32 hours. The interview is in reference to Pickens County Sheriff's Office case number 2020-013073. That's 2020-013073. I'm here present with over the phone with a victim. Sir, please state your full legal name.
My name is Angel O. Santos.
Please state your date of birth.
Address 2507.
Your date of birth, not your address.
March 6.
Okay, please state your social security number.
5.
We're not going to play that for you guys. Sorry.
56459.
Please state your telephone number.
850.
We're not going to play this part either.
Okay, please state your current address.
Or this part.
250.
Lots of things you don't get to hear. Sorry, guys.
Please raise your right hand for me.
I will.
Do you swear or affirm to tell the whole truth, nothing but the truth, so help you God?
I do.
Okay. All right. Can you tell me more about this case that I've talked to you previously about over a jail phone call that was made and something was offered to you? Can you tell me who contacted you before this phone call was made?
I believe it was Jermel Cromartie's girlfriend. Her name on Facebook appears to be like Petty Betty. I believe her name is Jasmine. She contacted me multiple times, and then she ended up getting a hold of my phone number. She called me and offered me different amounts of money for me not to go testify against Jermel in the court. And then on February 17th, she made a phone call. She talked to me for like 2-3 minutes, and then while I was talking to her, she brought up into the conversation that Jermel was on the line and he wanted to talk to me. So he was actually present in the phone conversation on a 3-way, I assume, and he spoke to me for like 4 or 5 minutes.
What did he say on that conversation to you specifically?
Well, he said, he said if I had my word.
So you can say that they were trying. What were they trying to do?
Had my word.
So you can say that they were trying. What were they trying to do? That's what you felt like they were doing is actually.
Yeah, the whole time I felt like that's what they were doing. You know what I mean? Putting a price tag on my life.
Okay. And you said this before this actual phone call took place. There was other. Okay. And you said this before this actual phone call took place. There was other. You said his girl. There were other incidents where she was trying to offer you the same thing. Can you explain a little bit more on that?
Yes, sir. She called me multiple times in the past, and she said his people and her people, apparently family members of his and friends, were trying to come up with a certain amount of money to buy me out.
Okay. Did she ever try to get you to meet up somewhere?
Yeah, she did. She was specifically, she wanted me to come back to Panama City and meet me, whatever she wanted to meet me. And then I said, no, y'all are crazy. I mean, that don't sound good. There's no telling if I come to Panama City, y'all might have somebody finish the job and kill me, so I won't be able to testify.
Mm-hmm.
She said, well, I understand that. And he said, how about if we meet in the courthouse? She wanted me to meet with her and her people at the courthouse in Panama City.
What does she want you to do there?
Get it notarized.
She wanted me to go file a motion to dismiss charges on Cromartie.
Mm-hmm. And why was that? What was she offering you for that?
I believe she was offering me, at that time, she was offering me $3,000.
Okay.
Ooh, 3 bands.
And then, so let's go back to the phone call. When you were on the phone call, what does ban mean? What did he say by ban? I'll give you a ban now and then one later. What does he mean?
Yeah, that's $1,000.
Okay, so he says I'll give you $1,000 now and then one later. So he's saying, can you elaborate on what he's saying?
Yeah, he said he give me a ban now, and then whenever everything gets dismissed or thrown out in court, he'll give me the other part.
Okay. So to your knowledge, have they contacted you anymore after that?
No.
No, they haven't contacted you anymore.
Not at all. Nope.
Is there anything you think would be more pertinent to this case that you need to inform me about?
I never got the band.
I believe, he mentioned something in one of the phone calls. In that phone call, actually, he said, because I kept asking him, what was behind it. Because he kept claiming he didn't do it. So I said, man, you did it. And I said to him, Melo, if somebody sent you to wipe me, to kill me, and if somebody's behind it, you need to tell me. You need to let me know what's going on. That way I know who put you up to the task.
Mm-hmm.
And he said, well, there's a lot going on. He said, you had a bunch of shit going on with your tails. And when he said tails, I believe he probably meant my baby mama.
Mm-hmm.
And, at this point, I'm still blind to the fact, like, I really don't know if somebody paid him an amount of money to kill me.
Yeah. I understand.
I mean, really, what I want from this case is I want closure, man. Like, if there was somebody behind it, if somebody contracted him to kill me, I want that person too. I want that person to pay for what they did, because if it is that way, he probably would have never done that.
Yeah.
But whenever that person came through and offered some amount of money for him to do what he did, that's when he, did it.
Let me ask you this: when she added you, you said she came in contact with you via, what was that, via Facebook? You said.
Yeah.
So when she added you on Facebook, did she send you messages at first?
No, she sent me a friend request, and I never accepted the friend request she sent me.
Okay. So
then,
based on her Facebook pictures, you're able to tell who she is.
Yeah.
You can identify her. Okay.
Yeah.
Okay. And then how did she get your number? Do you know?
I'm not sure. I think whenever we exchanged text messages, I sent it to her.
So did she give you her number first? Can you remember?
I'm not sure. I know in one of the messages she said, "Call me, please."
Gotcha. What's her number? Do you have her number?
Yes. The number is 850.
No. Yeah, it's not going to happen, guys. You don't get the number.
You can say without a reasonable doubt that she's the one that called you the day on the 17th. To make the three-way with you, Cromartie, where he offers you $1,000 now and then one after.
Yep.
Okay. All right. Please raise your right hand for me, sir.
Okay.
Do you swear and affirm that everything you told me was the whole truth and nothing but the truth, so help you God?
Yes, sir.
Okay. This now concludes the statement. The time is 11:40, 100 hours.
We can now get out of the closet. Because it sounds like he recorded that in the closet. Like he was whispering into a microphone.
On state rest.
All right, ladies and gentlemen, we're going to take another afternoon break. We'll start back at 3 o'clock. Remember to leave your notepads in the courtroom. Do not discuss the case amongst yourselves or with anyone else. Don't use your electronic devices to find out, check any sources about the case, and don't check any media sources. If you'll leave the courtroom at this time and follow the directions of the bailiff in the back.
Jury's going to file out.
3 o'clock.
3 o'clock.
3 o'clock.
I don't know what the jury's going to do. The defense, clearly the dude has counsel. So I think we've got the wrong case. Jermaine, I think is his name.
Everyone can have a seat. Mr. Williams?
Yes, Your Honor. I had previously reserved on an opening statement, so I will be making an opening statement, and my client has informed me he intends to testify.
Okay. Let's go ahead and take up the motion first. Your motion?
Yes, Your Honor. I'd make a motion at this time.
Directed verdict.
For a verdict of not guilty based on the state's failure to prove or to present evidence that in the best light would prove each and every element of their case.
Mr. Sullivan?
Your Honor, at this point, you have to take the evidence in the light most favorable to the state, and there's a plethora of evidence to prove a prima facie case for both charges in this case.
Okay. I'm going to deny the motion for judgment of acquittal at this time.
State was confident.
Mr. Cromartie, I'm going to ask the clerk to place you under oath. I'm going to ask you some questions about your decision to testify, and that's all the questions I'm going to ask you about, okay?
Okay, Kim Morty.
You'll raise your right hand at this time.
That's the name.
You do solemnly swear affirm testimony you shall give will be the truth, the whole truth, nothing but the truth, so help you God.
Okay. All right, sir, state your name.
Jamel Cromartie, sir.
Mr. Cromartie, Mr. Williams indicated you have made the decision to testify in this case.
I don't want to testify, sir.
Okay. Well, let me go ahead. I need to make some questions on that decision also, okay? You've indicated you do not want to testify. Is that correct? You understand that you have a right to testify.
Yes, sir.
You have a right to remain silent.
Did he flip?
Yes, sir.
The only person who can make that decision is you. Understand that?
Yes, sir.
And you can make that decision right now. And Mr. Williams, if he doesn't have any other witnesses, he can rest your case. Before he rests his case, if you decide you do want to testify, you can change your mind. You understand that?
Yes, sir.
If you do make the decision to testify and you're on the witness stand, you have to answer, once you finish the direct examination by your attorney, you understand you'll be subject to cross-examination by the state.
He just flipped his mind.
All right, and you'll have to answer those questions just like you answer your attorney's questions. Do you understand that? Okay. Is anybody forcing you to make this decision?
Yes, sir.
And you haven't taken anything that would impair your ability to make this decision. Is that correct? All right. Everyone satisfied with those questions?
Yes, Your Honor.
Okay, Mr. Williams?
Yes, Your Honor.
All right. Do you have any other witnesses to call?
I do not.
Okay. We want to go ahead and we've given we can take a small break if you'd like, if you need a break, or we can go ahead and go through the charge conference at this time.
Judge, if we could do the charge conference first, that way if there's any edits, I have time to edit it.
Okay.
When we take a break.
That's fine with me, Your Honor.
And I provided jury instructions to the court and defense counsel in that book.
And I'm to those. And I'm on page 2, attempted, Jamal Cromartie is accused of attempted first-degree murder in count 1.
Yes, Judge. So I spoke with Mr. Williams on this case. This instruction is required to be given in every homicide or attempted homicide case, absent an express concession that justifiable and excusable homicide does not apply. I believe that that's not an issue in this case. It's not what's being argued. There's no evidence that this is justified or excusable homicide. So I'm asking that that express concession be given so we can take this instruction out.
Say that again.
This instruction, Judge, has to be given the standard instruction.
Justifiable attempt. What you
Yes, page 2 for justifiable attempted homicide and excusable attempted homicide. It's the entirety of page 2. That instruction, the standard instruction, has language in it that says it has to be given in every homicide trial or attempted homicide trial, absent an express concession that it does not apply. There is no evidence in this case that this attempted homicide was justifiable or excusable. My belief that the defense is that Mr. Cromartie did not do it, not that it was excusable or justifiable. So I'm asking that the defense give that express concession so that we do not have to give this instruction. I think it would be confusing and more information than the jury needs to hear because there's no evidence to either one of these issues.
Mr. Williams?
Your Honor, I certainly agree the state's case didn't raise anything that would require an instruction by justifiable or excusable attempted homicide, and certainly our case wouldn't either. So I have no basis to object to that request.
Turn around talking to people.
It'll be removed. I'm on page 3.
Yes, Judge, this is the standard instruction for count 1, attempted premeditated first-degree murder.
This is a first-degree murder trial, and it's super fast. I think we had the wrong court pinned because we've got Jermel Cromartie that is being sought in the attempted murder of Angel Santos.
Problems with page 3. I'm on page 4, which are the lesser included.
Yes, Judge. All of these lesser included are the category 1 lesser included offenses that are mandatory, and they continue on to the next page as well. as far as the lesser included for attempted manslaughter by act, that is on the second page of which would be page 5. I have a section there that is kind of bolded and italicized and in brackets. My intention is to take that sentence out because it deals with the excusable or justifiable homicide instruction, which you will not be given. So that, I believe that one sentence at the end of that instruction would come out.
Any objection?
No, Your Honor. And then I believe onto the next page, the lesser included offense for battery continues as well.
Yeah, he attemptedly tried to shoot. He shot the guy on the phone multiple times, but then said it wasn't him. The guy's like, "Hey, I was in the hospital for 23 days and 8 months. I was laid up, lost my girlfriend, lost my job, everything. That's not fair." And he's like, "Look, if you'll just take $2,000, okay, I'll give you $1,000 now and $1,000 after. Just tell the state's attorney it wasn't me. It wasn't me." And he didn't. Instead, he went to the defendant or went to the investigator and said, "Yeah, it was him," and he tried to bribe me. So that's what we have.
Now I'm going through it. I've gone through the count 2. Any objection? Page 8.
Can I back up for a moment?
Yes, sir.
7, Your Honor.
Page 7 is the 1020 life findings.
Yeah, but I was just going to go through, I think, a grammatical error here. The start of the third paragraph. I could just have a moment.
The defendant's more interested in who's in court. He keeps looking back, and it looks like he's
Never
talking
mind,
to
Your
people.
Honor, I was misreading it.
Okay. All right. I'm at the page 8, count 2.
I don't know if this is an appeal. I think this is the initial trial. I think we had the wrong court case pinned because the name didn't match up. That's the chance we get when we play
No comment on that.
court roulette.
No problem with that, Judge.
Count page 9 is the defendant's plea of not guilty and the presumption of innocence, reasonable doubt.
Yes, Judge, those are all standard.
Objection.
All right, 10.
Judge, 1 through 5 are required. 6, I believe I'm going to ask to stay in. 7, I'm going to ask. 7, I think actually can come out. I don't believe there's been any evidence.
Any objection, Mr. Williams?
No, Your Honor.
8, I believe, should stay in and become 7. And I don't believe there's any evidence of 9 or 10, so I believe 9 and 10 would come out.
Or anything else on page 10?
Not from the state, Your Honor.
Mr. Williams?
No, Your Honor.
All right, page 11 is the expert, and there was an expert in the case.
Yes, Judge, that's the continuation of the same instruction from page 10.
Page 12 can come out. The defendant has not become a witness. We're on page 13. And Mr. Williams, are you requesting both paragraphs?
Yes, Your Honor.
Then on the general rules that apply to your discussion.
Judge, I believe the last 4 pages here are all standard instructions.
Mr. Williams, have you had an opportunity to review the verdict form?
I have, Your Honor.
Any objection?
No, Your Honor.
All right, the jury won't be back till 3 o'clock, so we'll take a break. Mr. Cromartie, if you need to take a break, they'll take you back in the back and give you an opportunity. And then we'll start back at 3 o'clock or there as soon as possible.
Yes, Judge, thank you.
We're in recess. 3 o'clock.
Okay, so let me see. Are we behind at all? Oh, that's live. 14th Judicial Circuit. Are they in? Are they in Central Time Zone? Did I just fade to black on you guys? I did. I faded to black. Sorry about that. We are professionals here too. Is this the same case where he made soft-set claims about driving? If so, that would explain his lack of defense. I don't know. I'm a little bit lost on this one. Jury's on their third break in 1 hour. They take a lot of breaks. Defendant is refusing to participate. Fade was nicely done. Yeah, it's my transition. Some people do like swishes and swoops. I just fade to black and then I come back. Northwest Florida. So yes, 3 o'clock. So they've got an hour. Wow, this case is just flying. It's hauling. It's moving so quickly. Okay, let's 14th Judicial Circuit. Okay, is it live again? I swear I'm in like a time warp. This show's live. What in the world is happening? I feel confused. Because it's 3 o'clock right now. Did they just start again? Okay. Take the world's shortest breaks and take a lot of them.
Everyone can have a seat. Williams, you may call your first witness.
Your Honor, at this time the defense will rest.
Ladies and gentlemen, both the state and the defendant have now rested their case. The attorneys now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Sullivan,
I swear they probably already got the verdict. Okay, this is our best. Listen closely, guys. This is the explanation of everything. Oh, I'm going to move out of the way so you guys can see. I'll go up here or over here because nobody's over there. I might sit in the chair. Is that all right? I might take a seat. There we go. I can see better from here. Okay, so because he didn't testify, the defense lost the ability to give their opening statement because the opening statement is a precursor of what you're going to hear in the testimony. There was no testimony, so he lost the opening statement. Even though he thought he was going to testify, he then chose not to. And so there's been no questions of witnesses, no testimony by the defense, and now we're straight on to closing testimony. It's been super fast. There we go. Focus, LG. My voice is my password. There you go. PowerPoint is up.
Plug into this one here.
Yet the only motion they made was for a directed verdict. And it was a half-hearted attempt that almost didn't even warrant a response by the state. I think the whole response by the state he did while he was standing and then promptly sat down. There we go. Here we go. Florida v. Jamal Cromartie. Attempted murder. Bruh. The attempted murder of bruh.
So, ladies and gentlemen, at this point, you've heard all of the evidence. You've seen all the evidence. You've heard all the testimony. In a few moments, the judge will give you the law that will apply to this case. Obviously, the screen's not working. I'm going to try to go through some of this, but you will get a copy of the instructions that the judge will take back, that he'll read to you. You'll get a chance to take back with you. and you'll get to see these instructions again. So the first charge that Mr. Cromartie is charged with is attempted first-degree premeditated murder. And what the judge will tell you in a few minutes is that I have to prove 3 things beyond a reasonable doubt for you to find the defendant guilty of that charge. The first thing is that Jermel Cromartie did some act intended to cause the death of Angel Santos that went beyond just thinking or talking about. He did something other than thinking or talking and intended to cause the death. The second thing that the state has to prove is that Jermel Cromartie acted with premeditated design to kill Angel Santos. And the third thing is that the act would have resulted in the death of Angel Santos, except that someone prevented Jermel Cromartie from killing him, or he just failed. Those are the 3 things the state has to prove beyond a reasonable doubt. And the judge will tell you what premeditated design is. So there's a couple instructions on that. He'll read those to you. You'll get to see those. But I want to talk a little bit about how the evidence applies to these 3 things and how I've proven those 3 things beyond a reasonable doubt. So the first thing, that Jermel Cromartie did some act intended to cause the death of Angel Santos. He shot him. That is the act. It went beyond thinking about it. It went beyond talking about it. He did something. And it was intended to kill Angel Santos. You don't shoot somebody with any other intent.
This was the actual crime.
You come to the courthouse, you have life experiences, you have common sense. You can use your common sense. You don't get to, when you go back to the jury room to deliberate, you don't have to leave it out here in the courtroom. You take it with you. And it's common sense. If you shoot somebody, there's a reason for it. And that reason is to kill them. Jermel Cromartie acted with premeditated design to kill Angel Santos. And this kind of plays in a little bit with count 1. Because, yes, you can say,
Mr. I hate to interrupt you.
Yes, Judge.
Y'all come forward, please.
Yes, Judge.
Y'all come up here. Let's talk just for a minute. Just the Twix of us. The trace of us. What's 3? I'm dying to know what he's talking about. Quick conference. We have an issue. We have a dilemma, a circumstance that needs addressing. How would you like me to handle that? Objection counter is still at 0. Seriously. A thruple. No, because thruple is used in another setting. Judge saw a meme that he just had to share. He just could not wait.
I apologize. Mr. Sullivan, goes right ahead.
Thank you, Judge. So the second element, the premeditation, kind of goes hand in hand with the first element, that he intended to kill Angel Santos. Because theoretically, somebody could be cleaning a gun, doing something, accidentally pull the trigger, and you could shoot somebody without intending to do something, without intending to do so. But in this case, we've got 12 shell casings that were collected. That gun was fired 12 times. That means Jermel Cromartie pulled that trigger 12 separate times. You've got at least 8 bullet holes. You saw the photographs in Angel Santos. This wasn't an accident. You don't accidentally shoot somebody 8 times.
We might have missed some of court.
He intended to shoot and kill Angel Santos. He intended to kill him because after he shot him, he left him for dead in that field. He didn't call for help. He didn't attempt to help. He left him lying like a dog to die in that field and went about his day. That's not the only evidence of premeditation that you have, because they didn't just happen to get to this field where this argument broke out, and in the heat of passion, he got angry and shot him. No, they were at his house earlier when, for whatever reason, he gets upset, he grabs Angel and marches him at gunpoint to where he ultimately shoots him. That entire time, the entire time they walked, and you saw the photographs, it's not that far, but it's long enough for him to reflect on what he's doing. And the judge is going to tell you in that instruction on premeditation that there has to be a period of time to reflect. That is more than sufficient enough time to think about what he was about to do. And he continued on. He continued to pull the trigger not once, not twice.
Not 3 times either.
12 times.
And he missed how many times?
That is premeditation.
25%?
The simple fact is that he failed. By the grace of God, Angel Santos, despite being shot so many times in so many different parts of his body, he survived. He failed. And that's the third element. State's proved all 3 elements beyond a reasonable doubt. And I ask you to find him guilty, count 1. Now, for count 1, there are what's called lesser included offenses. And I'm not going to go through all of them and what all the elements are for all of them, because the judge will read that to you in a moment. But I'll tell you that those lesser included elements are attempted second-degree murder, attempted manslaughter by act, attempted aggravated battery, and attempted battery. And the easiest way for me to explain lesser included crimes is to think about it as like a recipe. So if somebody wanted to make cookies, let's say they wanted to make chocolate chip cookies, you put in flour, you put in sugar, you put in your other ingredients. Those ingredients are elements, the things that I would have to prove beyond a reasonable doubt. And when you put those elements together, throw what you got in the oven, bake it a little bit, you get a cookie, a chocolate chip cookie. That's what you're making. But let's say when you're making, you add another ingredient. You add M&Ms. It's a similar, maybe you've got a chocolate chip cookie with now M&Ms. It's a similar
You have me at chocolate.
But it's also a little bit different. Crimes are the same way. There are degrees of crimes. First-degree murder, attempted first-degree murder, attempted second-degree murder. They're similar, and the elements will overlap a little bit. But there's also that extra ingredient. And in this case, that extra ingredient from attempted second-degree murder to attempted first-degree murder is premeditation. And the judge will tell you what attempted second-degree murder is, and it's essentially doing something that's so dangerous with a depraved mind that it could have resulted in the death. You didn't necessarily intend to kill somebody, but it could have. That's the difference, the extra ingredient. And if you go down the list, you start taking away ingredients. And so you finally get to battery, and battery is simply touching somebody against their will. So when you get back to the jury room, you have several choices, and I'll show you the verdict form here in a moment. But you'll have to choose between all of those crimes. And the judge will tell you that it is your duty and your obligation to choose the highest crime that's been proven beyond a reasonable doubt. So I submit to you that I have proven attempted first-degree murder beyond a reasonable doubt. But because that's the highest crime, that also means I've also proven attempted second-degree murder. I've also proven attempted aggravated battery. I've also proven attempted battery. I've also proven attempted manslaughter by act. You may get back there and you may look at the elements and say, well, yeah, that's been proven, that's been proven. But your duty is to choose the highest crime that has been proven. After you make that determination on the verdict form, I'll show you the verdict form here so you can see.
I've pre-filled out the verdict form for you.
So the first thing you'll choose from is A through F, those crimes listed in descending order. And then the final choice, not guilty. You have to choose one of those. And then there's a special findings section. If you find the defendant guilty of any of the crimes in count 1, you'll then have to choose one of the 3 choices for the special findings. The special findings deals with the use of a firearm. And you'll have 3 choices. Either he actually possessed a firearm, which means he had it on him, or he had it near him with the intent to use it. He actually possessed the firearm and he discharged the firearm, which means he pulled the trigger and discharged it. Or the third, he actually possessed the firearm, discharged it, and caused great bodily harm to Angel Santos. And I submit to you that that's been proven beyond a reasonable doubt, that Jamel Cromartie actually possessed the firearm, discharged it, and caused great bodily harm. You saw the photographs. You saw the injuries to him. You saw the photograph where they had to cut his stomach open to do the surgery.
Whoa, you showed that.
You've got the item and evidence, the bullet fragment that was taken out of his body that will go back to the jury room with you, along with all the other evidence.
You showed that? Ew.
That is great bodily harm. And the judge will
I think we missed that this morning.
all of this as well. I want to move on to count 2, the tampering with a witness. The judge will tell you that to prove count 2, the state has to prove 3 things as well. The first thing is that Jermel Cromartie knowingly offered pecuniary benefit or gain to Angel Santos. Pecuniary benefit or gain. What does that mean? It means money. He offered money, payment of some sort, some financial benefit or gain to Angel Santos.
2 bands.
The second thing the state has to prove is that Jermel Cromartie did so with the intent to cause or induce Angel Santos to withhold testimony from an official proceeding, evade legal process summoning him to appear as a witness in an official investigation or proceeding, or to be absent from an official proceeding to which he has been summoned by legal process. That's a lot of words that simply means he did it with the intent to prevent him from cooperating and testifying. That's what that means. The third thing the state has to prove is that the official investigation or proceeding affected or attempted to be affected involved the investigation or prosecution of a first-degree felony. And the judge will tell you that attempted first-degree murder is a first-degree felony. That's been proven beyond a reasonable doubt. If you go to the jail call is really the only evidence that you've got of this crime. You've got the jail call, and you've got the statement that Angel Santos gave after the jail call was discovered, where he said, yes, Jermel called me, he offered me money, he talks about it. That's really the only evidence of this crime. But that is the entirety of this crime, is that jail call. I want to go through some of the things that Mr. Cromartie said on that jail call, because it not only proves the tampering, but it also proves that he's the one who shot Angel Santos. The very first thing that comes out of Mr. Cromartie's mouth when Angel's on the phone,
Bruh.
So you're going to rat me out. Doesn't get any more incriminating than that. What is he ratting him out about? He's ratting him out about shooting him. Angel goes on to talk about, how this affected him and what happened. And Mr. Cromartie says, I don't know where my mind was at, justifying, why he did this. If anything, if you feel like it was me, bro, I apologize. Then a little bit later, he goes on to say, I'm sorry.
You think it's me? I apologize. You're wrong.
He goes on to pull at Mr. Santos's masculinity, so to speak. He says, keep it real, G. What kind of real G shit? What kind of life is that? If you're a real G, no real G going to no state attorneys. And then he says, you'll be on black and white. I don't know if you caught that or not. But what does that mean? It means if he goes, his name's going to be in the police reports. His name's going to be on the witness list. His name's going to be in the discovery that's provided to Mr. Cromartie. He's telling Angel, if you go forward and prosecute, your name's going to be written down and everybody's going to know you're not a real G. You're a rat.
Different from an OG. A real G.
A little bit later, Angel says, there was no reason for that shit to go down how it went down. Mr. Cromartie's response, yeah, you're right. You're right. Again, proving that he was the one to do it. He says several times, I can't say nothing over this phone because he knows it's being recorded. He knows that he can't come out
and it's a good thing
and
he didn't
say,
incriminate
I'm
himself.
sorry I shot you. This person was behind it. He even says at one point, I'll tell you when I get out. Just get me out, but I'll tell you later. I can't do that on this phone, bro. You've got the statement from Angel that says when they're talking about bans, what he's referring to is $1,000. But you've also got the proof from Mr. Cromartie that's what he meant when he said bans. Because he says, they give you bans straight up, and then I'll give you the other when I get out. That's the first time that conversation comes up. But then he goes on and says, you're going to have that, bro. And the thing about it, if you get 1,000, you get a ban or whatever first quarter, bro, you got to let word be said that I ain't had nothing to do with that. And the prosecutors and the state attorney got to hear you, or they got to get a note from you, and then you'll get the other half. Ladies and gentlemen, that is offering pecuniary benefit with the intent to cause Angel Santos to not be involved in this proceeding. That is tampering with the victim.
I think I unmuted
And I ask
just
you
a
to
cough.
find him
Sorry about
guilty
that.
as charged of that offense as well. The last thing that I took of note from that jail call, Mr. Camardi says, you're going to get your end of the bargain. Keep the shit silent. Keep silent. You're going to get to take back this evidence, all of the evidence that's in it. You're going to get to review whatever you want. I want to focus a little bit on this documentation. You saw the photograph that there was some documentation found at Jermel's house that had Angel Santos' name on it. To be honest, the photograph isn't that good. You can see it's got Angel's name on, a couple letters. But when you get back there, I'm going to just point out some of the things that are here.
Here comes examination
in this
time.
documentation.
It's time to glove up.
Because I think it's important. So you've got this letter. I think this envelope showed up in the photograph. It's red envelope. If you look inside, you've got photos of Angel's son, family photos of him with his son, and other various photographs, family photographs. You've got letters from Florida Department of Revenue. You've got pay stubs. You've got things that were sent to him from his family. You've got court documents. You've got a photograph of his driver's license. An envelope addressed to him. You got this. Now, what you're going to see if you look through these documents, you'll probably see that at some point in Angel Santos's life, he was incarcerated. What you've got is the most prized possessions of Angel Santos. When he was released from custody, he went to stay with his, what he thought, friend, Jermel Camardi. And this is essentially all he had in life. Some photographs of his family, a copy of his social security card, a copy of a driver's license, a diploma, a copy of a diploma. This is everything that mattered to Angel Santos. This is the extent of his worldly possessions at that time. And they were found at Jermel Camardi's house. Why? Because he was living there. He was staying with Jermel Camardi. You heard that in the call or in the recorded statement that he gave to law enforcement. He had been staying there for a little bit of time. And the reason that that's important is because you've got several witnesses who have stated that Jermel Camardi was the person who shot Angel Santos. But at the end of the day, Angel Santos is the only person other than Jermel Camardi who saw and knew what happened that day. Those other witnesses heard Angel tell them, and he told them in a moment of desperation. He thought he was dying. Why else would he give anybody else his name other than the fact that Jermel was the person who shot him? These were what he believed to be at that time his last threats. But the fact that he was close with Mr. Camardi and was staying there is important because there's no way he misidentified the person that shot him. This wasn't a stranger that walked up to him in the middle of the night and shot him. This was somebody that he was intimately acquainted with. There is no doubt that Jermel Camardi shot Angel Santos and then proceeded to do everything in his power to prevent Angel from coming to this courtroom today and testifying and putting him away. And I ask you to find the defendant guilty as charged of attempted first-degree premeditated murder with actual possession, discharge of a firearm causing great bodily harm, and tampering with the victim. Thank you.
Mr. Williams?
No argument, Your Honor.
No closing argument. Whoa. Whoa. Defense did nothing. Nothing.
Nelson, see if I left my glasses in the office.
Nelson, get my glasses. Oh no, they're doing more than not trying. They're actively not trying. I mean, they're doing more than not doing anything. They're actively trying to not do anything. I can just imagine the little meeting they have in the jail as this court date's coming up, and it's like they're talking over their plan.
They could be.
And he's like, "Okay, here's what we're gonna do." He's like, "No, wait, I've got an idea. Listen,
While
lawyer,
we're waiting, if I may approach to replace these.
You may.
I think they're just gonna crash and burn. Just let the state do their thing, and they'll mess it up. So we just don't do anything. Just wait, and let's just see what happens." And that's what they did. He's like, bruh, I've got this new idea. Nobody's done this before. Ineffective assistance of counsel. Can you get reprimanded from this? Man, is there a duty to defend?
I got some. I can do it.
We need some legal advice as the bailiffs are rearranging the furniture in the courtroom. Yeah, there's an appeal in this guy's future. I can smell this one coming. No defense opening statement. No defense closing. And also no cross. No cross.
Thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Jamel Cromartie, the defendant in this case, has been accused of the crimes of attempted first-degree premeditated murder and tampering with a witness. There's tampering with a victim. I now instruct you on the circumstances that must be proved before Jamel Cromartie may be found guilty of attempted first-degree murder. As to count one, to prove the crime of attempted first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Jamel Cromartie did some act intended to cause the death of Angel Santos and went beyond just thinking or talking about it. Jamel Cromartie acted with a premeditated design to kill Angel Santos. That would have resulted in the death of Angel Santos, except that someone prevented Jamel Cromartie from killing Angel Santos, or he failed to do so. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing.
Sorry, I had some typos.
In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he's accused, there may be evidence that he committed some other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of attempted first-degree premeditated murder are attempted second-degree murder, attempted manslaughter by act, attempted aggravated battery, and attempted battery. And I think that should be an aggravated battery. Is that correct? You see where I'm at?
Judge, it's attempted manslaughter by act, attempted aggravated battery, and attempted battery.
To prove the lesser included crime of attempted second-degree murder, the state must prove the following two elements beyond a reasonable doubt. Jamel Cromartie intentionally committed an act which would have resulted in the death of Angel Santos, except that someone prevented Jermel Cromartie from killing Angel Santos, or he failed to do so. The act was eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment
I'm going to turn down the instructions for just a minute because we're not going to get to these lesser included. It's either going to be all or nothing, I think, from this jury. The poll says there are only two options. The poll says, will the jury find Jermel Cromartie attempted to kill his bruh? Yes or no, in that order.
To prove the lesser included crime of attempted manslaughter by act, the state must prove the following element beyond a reasonable doubt. Jermel Cromartie intentionally committed an act which would have resulted in the death of Angel Santos, except that someone prevented Jermel Cromartie from killing Angel Santos, or he failed to do so. However, the defendant cannot be guilty of attempted manslaughter by act by committing a mere negligent act. Every person has a duty to act reasonably and to use ordinary care toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of attempted manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act which would have caused death. To prove the lesser included crime of attempted aggravated battery, the state must prove the following two elements beyond a reasonable doubt. Jermel Cromartie did some act toward committing the act of aggravated battery that went beyond just thinking or talking about it. He would have committed the crime except that someone prevented him from committing the crime of aggravated battery, or he failed. The crime of aggravated battery is defined as actually and intentionally touching or striking the victim against his will, or intentionally causing bodily harm to the victim, and in doing so intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement to the victim, or using a deadly weapon. To prove the lesser included crime of battery, the state must prove the following two elements beyond a reasonable doubt. Jermel Cromartie did some act toward committing the crime of battery that went beyond just thinking or talking about it. He would have committed the crime except that someone prevented him from committing the crime of battery, or he failed. The crime of battery is defined as actually and intentionally touching or striking the victim against his will, or intentionally causing bodily harm to the victim. If you find that Jermel Cromartie committed a crime in count one, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm, and in doing so caused great bodily harm to Angel Santos, you should find the defendant guilty of the crime with discharge of a firearm causing great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Jermel Cromartie committed a crime in count one, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm, you should find the defendant guilty of the crime with discharge of a firearm. If you find that Jermel Cromartie committed a crime in count one, and you also find beyond a reasonable doubt that during the commission of the crime, he actually possessed a firearm, you should find the defendant guilty of the crime with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, and any machine gun. To actually possess a firearm means that the defendant carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime.
96%, 97% think he's guilty.
To prove the crime of tampering with a victim, the state must prove the following three elements beyond a reasonable doubt. Jermel Cromartie knowingly offered pecuniary benefit or gain to Angel Santos. Jermel Cromartie did so with the intent to cause or induce Angel Santos to withhold testimony from an official proceeding, evade legal process, summon him to appear as a witness in an official investigation or proceeding, or be absent from an official proceeding to which he has been summoned by legal process. The official investigation or proceeding affected or attempted to be affected involved the investigation or prosecution of a first-degree felony. The court instructs you that an attempted first-degree premeditated murder is a first-degree felony. Official investigation means any investigation instituted by a law enforcement agency or prosecuting officer of the state or a political subdivision of the state with the Commission on Ethics. Official proceeding means a proceeding before a judge, a court, or a grand jury. The defendant is in a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and the information for each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following.
And he exercised that right.
A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty.
And then
it is
your
up
cookies.
to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's question? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered to receive any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are dependent upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding the verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. Verdict. We, the jury, find as the defendant Jamel Cromartie as follows. Count one. Check only one. The defendant is guilty as charged of attempted first-degree premeditated murder. The defendant is guilty of attempted second-degree murder, a lesser included offense. The defendant is guilty of attempted manslaughter by act, a lesser included offense. The defendant is guilty of attempted aggravated battery, a lesser included offense. The defendant is guilty of attempted battery, a lesser included offense. The defendant is not guilty. Special findings. If you find the defendant guilty of one of these offenses in count one, you must further choose whether the state has proved any of the following beyond a reasonable doubt. We find the defendant actually possessed and discharged a firearm causing great bodily harm. We find the defendant actually possessed and discharged a firearm. We find the defendant actually possessed a firearm. As to count two, the defendant is guilty as charged of tampering with a victim. The defendant is not guilty, signed by the foreperson and dated. A separate crime is charged in each count of the information, and although they have been tried together, each crime, the evidence applicable to it, must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken back to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberation. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberation, jurors must communicate about the case only with one another and only when all the jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop.
You should all go to the restroom with them.
You will not communicate with any person outside the jury about this case. Until you've reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberation. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. That includes smartwatches. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats, where they will be guarded by the bailiff while you deliberate. They will be secure. If you need to communicate with me, send a note to the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent in the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has a right to violate the rules.
For 2
we all
centuries.
share. Mr. Sullivan, Mr. Williams, does that reflect the instructions agreed upon by the parties?
Yes, Your Honor.
Yes, Your Honor.
All right, I believe it's Ms. Turner. You're our alternate. You will not be going back to deliberate. We only need 6 jurors.
We just outed one of the jurors.
More than we need because we picked
Ms.
all
Turner.
the juries on Monday. We try the cases throughout the week. I let all the other jurors know that Ms. Turner will not be going back there. I've had jurors wait because you're supposed to wait till everybody's there, and I didn't let them know that the other juror was not coming back. With that being said, Deputy Dexter, if you'll leave your electronic devices, and if any of you have a pocketbook, you'll need to leave that in your seat. They'll be secure. I'm going to hand you the verdict form and the instructions. If you'll follow Deputy Dexter, Ms. Turner, if you'll remain in your seat.
Jury goes out the main doors like everybody else. Except for Miss Turner.
You have fit this or things like that.
Who's talking? What are they saying? Update on the case that we were trying to follow, the Hannah Payne.
Everyone can have a seat.
They still have not seated the jury.
Ms. Turner, thank you for your service. I know it's not fair to bring you here on Monday morning, make you stay all Monday morning, make you come back today and stay most of the day, and then not get to deliberate. But you have provided a great service, just making yourself available for jury service. Many times I've run out of jurors. I've had jurors not come back. With that being said, that concludes your jury service. You're free to go about your day. You can leave the courthouse. If you'd like to remain in the courtroom, wait on the verdict, that's up to you. But if you'd like to go, you're free to go. Thank you for your service.
Okay, and we just got a note from the bailiff. It looks like the jury has a verdict. I'm just kidding. This might be so quick. This might be the fastest one ever. Another escaped inmate in Pennsylvania.
All right, everyone can have a seat.
Y'all be seated.
Anything else we need to take up?
Bros and bros
We'll be in
included.
recess.
And now we're in recess. Okay, so now here's our dilemma. We now have to wait. We have to wait for just a minute. Wait for just a minute. Every single time they take a break, it's like seconds later they come back live. So if this continues, let's see. Let's go to, where are we? We're in the 14th, Florida 14th. 14th. Florida 14th Judicial Circuit. Shows live, but it stopped. Okay, so now we just get to sit here and refresh until something happens. Now, Florida 14th has a couple different channels. They air a couple different courtrooms. So we're waiting for Judge Brantley S. Clark Jr. from Bay County with this felony trial. Verdict clock. Oh, man. I would, but my kids used the iPad and did not charge it. I have no battery. Okay, let's assume they just started deliberating right now. Reset, start. It's going to be on my watch. Every time you guys want to see what it is, I just have to do this contortionism thing and tip it back, and then you guys look at my watch. That's going to be the verdict clock, because that's about how this court is running. Crazy trial, just a crazy trial. Can they deliberate in the hallway? I think they've just finished. They're just filling out the form now. And they're looking at each other and going, you guys, can you believe what just happened? Now, this is bizarre. I've seen before. I've seen times. Let's count out loud for the verdict clock. 1 Mississippi, 2 Mississippi. Keep counting, Zoe. Keep counting. We are going to go with that. You are a verdict clock. I'm going to check in with you periodically, and you just say what the number is. There are times when the best defense is to just say silent and say, look, they can't prove it. They can't prove it. And I've seen that and it work well. But this is a little bit different in that they basically did nothing. Come on, where's the 14th? Okay. We'll keep refreshing there. It is almost 5 o'clock right now. I expect we should have a verdict in about 20 minutes. 20 minutes is about how long it takes to have a bathroom break and fill out the paperwork, and I think that's how long it's going to be. How long has it been? About a minute and a half. So they're I think they've got their foreman now, and they've all decided. So now they're just to figure out the paperwork. I've seen trials where the defense wanted to. Oh, you want to see RA contort? I have to twist my arm. You have to be careful because I might get a message or a text and it will just show up on screen. But that's the verdict watch right there. Literally, verdict watch. I've seen cases where the best defense was to basically say you can't prove it and we don't have to prove anything, and that works. But this one took it to a new level where they just did not involve themselves in anything, and there was no cross-examination of any witnesses. Why no cross-examination? And I think we missed a day, but this court likes to delete their videos as soon as they go offline. So, I mean, we've only got the last hour or so available to us. And even that is now gone. They've deleted all the videos. Everything we just watched is gone. Yeah, I was flashing my guns. I had to be careful so as to not rip my shirt. I didn't want to rip my shirt when flexing. But will they get a new trial on appeal? I don't think so. I don't see what the court did wrong. We missed the beginning and the middle. Yes, because the jury was selected on a Monday, and they probably started on Monday. So we probably had a little bit... let us know when we pass 5 minutes. 3 minutes and 20 seconds right now, 3:20. There's only one prosecutor today. There may have been another prosecutor yesterday, but we only saw the one today. Anyway, I was saying what time it was. It's 5 o'clock, almost straight up. We're about a minute and a half away from 5 o'clock. And at 6 o'clock, something really special happens, and that is that Dr. Joe Corcoran has a live interview with Nick Whitney. So I have redirected us to his channel. So when we end here, also at 6 o'clock, I have a dinner I need to be to, and I'm supposed to be wearing like a suit and tie and be all fancy and smell nice. And I think the smell nice is like a bonus, but I'll at least do the first ones. So I've got to be dressed up and going out to dinner. So I don't know how to do this. I need somebody to record the 14th Judicial Circuit of Florida as it happens for the verdict, because it will be like 5 minutes and it's gone. And there's no way you cannot ring the bell on this channel. There's not an option to ring the bell and be notified when they go live. So it's like either you get it or you don't. We might need a couple people to go all out and track this. Does everybody know how to record a video from YouTube and save it and then email? It'll probably be emailable. The file's going to be so small. It's going to be like a minute and a half long. It'll probably fit in an email. But I'm going to need some help from somebody who has the means and capability to do that, because I'm going to be getting ready for my dinner or at my dinner when this happens. Man, this is just crazy. Still no jury seated for the other trial, at least not finalized yet. No defense at all. Inaccurate representation come into play. Here's what I think happened. I think that Mr. Angel actually didn't show up. That what we heard from him, the recording from the jail cell, the interview with the police, I think that happened early on. And then like the money showed up and he's like, yeah, I'm not going to testify. And it's like, it's okay. We'll just use your recorded statement. I think that's what happened. Don't forget to fluff up your headphone hair. Oh, yeah, for sure. I'm going to do that. There's a first-degree murder case of mail carrier in British Columbia by two guys who escaped jail. Wish Canada allowed LNC in court. Yeah, mail carriers. Man, be nice to the mail carriers. Seriously, do you know what they have to go through day in and day out to bring you the mail? putting up with like vicious cats and everything. I barely know how to join a meeting in Zoom. Sorry. This is just a YouTube channel. It's a YouTube channel that just needs to be recorded. Instructions, please. Let's see. Someone could take a video from their phone while it plays on their TV or tablet. They could. That's probably the least effective way. It's very difficult on audio and video that way. Is it kidnapping you to portal us to another stream? No, I'm going to portal you to Dr. Joe Corcoran's channel, which he's not live yet. It's going to be just under an hour before he goes live. Just rewatched his pretrial hearing. He was offered 2 deals, one for 20 years and the other was 25 years. He was telling the judge that his attorney was of no help. He's like, really? I'll show you no help. I probably need to get a part-time job as a mail carrier just for the miles. I need to walk more and then probably run more. Ed, what needs to be recorded? Easy for you to do. Ed, we're looking at the 14th Judicial Court. Let me show you. Let me bring this over on the other screen. Bring this one over here. Shrink that one down. Okay, here we go. This is what we have right here, the 14th Judicial Circuit. I'm going to go big. We're looking for a specific case, so we can see this. Judge Clark is who we're looking for. Oh, thank you, Mrs. Ray. He as soon as it's over, he deletes the live stream. It's gone. So we constantly are refreshing, trying to catch it when it's here. And it's not there right now. So there are several other channels that sometimes go live. There are other courts in 14th Judicial Circuit that will go live at the same time as Judge Clark. But we need Judge Clark for the verdict of that case. It's the felony trial. And so we just have to, and because even though I'm subscribed to the channel, look at this, you try to ring the bell and it's either unsubscribe or disabled. Those are your options. You cannot actually be notified when this court goes live, which is really frustrating. So I need somebody to just sit here and refresh, and when that live stream pops up from Judge Clark's courtroom, open it up and record the whole thing, and then just send me the file or share it over a Gmail or something. Just need audio and video. That's it. Screen record from an iPhone. That may work. Make sure it's capturing audio of the video you're recording and not your audio and whatever's happening on screen. Do we really need the verdict, though? Really? Says Debbie. I'd like it just in case something happens. Difference between a bro and a bruh. It depends which one's in the right. I think a bro is in the wrong and a bruh is in the right. You got it? Thank you, Edsy. I appreciate that. And then if you're able to reach out to me on the burner phone, if you're able to get it. And if you don't get it, it's not the end of the world. We could probably look up the case and figure out what happened. But it's always nice to get conclusion to people who follow a case. And we just barely got vested in this one. We just barely got a significant interest in seeing what happens to our bruh. There's also bra. Bra is like nah, though, right? Bro is a good friend. A bra is someone who isn't. Also, brazier. Crazy Cat Queen, I think that's different. Realize they're probably the same root word, probably based in Latin or French. Time checks, Becca Lynn. We're at 10 minutes, 20 seconds. I don't know what I'm having for supper. I got invited to this meal, and we have to get ready. Bra is more of frat boy. Let's see. Mickey says, can you please take one day to review the Maya trial plaintiff's motions for sanctions before 12:15 hearing? No one reviewed these. I'm so curious. No one's reviewed the plaintiff's motions? They were the first ones out, weren't they? The plaintiff's motions for sanctions that came out, I think, before the court was finished. Are we talking about the same thing? There's going to be another plaintiff's filing response to the defense directed verdict motion for a new trial that'll be due by the 11th. Another prison escapee in Pennsylvania. What was he in for? Nurse forgot. We might pick that up tonight after my dinner if he's still out on the run. Of course, it's colder now. It's a little harder to stay out at night and hide. Janet Tucker with the education. It's always nice to receive a little bit of proper education. The German name for bra is Holdzum from Floppen. Yep. Okay, we're going to keep refreshing here in case we're missing it. It's not happening yet. I can't believe you read that. I'm excited. It's been a good day. I mean, we haven't had the case we wanted yet. It still has not started. Also, just an insight, this case we're trying to pick up, it's only about a week long, so it's not a long one. It's not going to be huge and in depth like some of the other trials. It's not going to be a Alex Murdaugh or a Maya trial as far as length goes. Probably about a week long, and so we'll move pretty quickly through it. I doubt there's going to be a lot of very slow days. You need to change the title on this stream too. Did I not already change it? Judge Brantley Clark, Bay County Felony Trial. Yeah, I updated this one. Thank you, I Rescue Dogs. I saw that again as soon as it started and updated this one. You got me in a weak moment. Plus, there's nothing in and of itself that's offensive in that little thing we read. We'll keep on refreshing. Ooh, they got some first appearances. Oh, they're deleting stuff is what they're doing. This was a day ago. There's like an intern who runs YouTube, and all they do is just delete stuff. Now we're down to, they've only got 5 videos there. Hey, you want to go out for dinner tonight? No. Who is going to be my date?
You've got a daughter.
I think everyone else is going to bring an adult date, not a youth date or a child date. The agenda I sent you for the Maya trial, it lists a discussion of motions for sanctions will be addressed. Jess, I see that. That's on the 15th. And it's going to address a lot of the different things that we've covered so far, and in addition to the stuff that the plaintiff filed before the case was over, when they asked for sanctions early on. Tied clothing to make a rope and escape through the ventilation system. This is next level. Drug related and state parole violations. He's not a high interest escapee at this point. The next prediction was 12 minutes. We're at 15 minutes right now. 15 straight up. So let's refresh again. We're in Verdict Watch. I want so badly to play the music. But I need to go change into a suit and get smelling nice. Look, they're deleting stuff as we speak. They're down to 3 videos on the channel. There is not much on this channel at all. Some of the old movies, there's just not a lot here. Stuff from a year ago. And then, boom, that's it. They're all about transparency, but only in the moment. Thanks, Kim, for refreshing for me. I think we're going to transfer everyone over to Dr. Joe's channel right now. So I can go get dressed because I also need to drive there and be there by 6. So I've got 50 minutes to smell nice, look good, and get there. Chris says, I'll be your date. Mrs. R.A. She doesn't want to go, but she also does not want someone else to go in her place. I think that's where she's at. Oh my goodness. Leave to get dressed. I've got this, says Ed. We've got this. Okay. You guys just want to see me in a suit and tie. I think, Mrs. Ari, can you grab that tie over there on top? The green one? Yeah. I think this is going to be our tie today. I've been saving this for a special occasion, and this I think is the perfect one. We have a pickle tie. We have a pickle tie, which I think would be good, appropriate. Now she really doesn't want to be there. She's like, if you're wearing the pickle tie, I won't be there. It's nice. It's really nice. Oh, it's like silk. It's got a nice little sheen to it. Let me file that. I'll throw that on the ground. You guys, check this out. Oh, you can't see it. Why? Because it's green, but it has pickles. You can see the pickles. Let me switch to a different camera so you can see. This is the tie I think I'm going to wear tonight with the suit. It looks good. Looks good. Imagine that in like a full Windsor or even a half Windsor, I think is what I'm going to go with. Because it's a good size. It's a thick tie. If I do a full Windsor, the knot's going to be like the size of Manhattan. Okay. But is it scratch and sniff? By the end of the dinner, I imagine it will be sniff at least. Because I tend to spill. And a tie is like a mini bib. Keeping it classy. That's what we do. So, that's a dinner cancel tie. Ivy, I'm doing it. I've got to go get ready right now. I would stay on here with you guys, but really I've got nothing to do other than run out the door as soon as I'm dressed. So, Mrs. R.A., do you want to talk to people?
I haven't watched this at all. I don't know anything that's going on.
It's okay. We don't know what's going on in this case either. We just picked it up and it's random. I can run and put my suit on and you can say hi to everybody and then we can trade. Yeah. I will give you a link to the other stream that starts in just a little bit. The stream that we're looking at right now, if you just go to YouTube and look for 14th Judicial Circuit of Florida, that's where the case is going to appear. And it's going to be Judge Brantley Clark is the case we're looking for. But I don't think it's going to happen. And at 6 o'clock in about 45 minutes, we've got Dr. Joe C, whose live interview with Nick Whitney is going to start. So we want to patch everyone over there so they can get there. I will give you the link to the other stream for sure. I'll send everyone over there. Can you transfer the timer to Mrs. R.A.? Do you want to wear the watch for a minute? Here, bring your arm over. If we do this quickly, it won't reset and have to need a new password. Slide your arm.
I need to get pretty too. It's got to be the other arm.
Let's
I got to do that arm.
Let's do this.
Okay.
I can't. It has to. It can't lose contact with skin, or else it thinks I've taken it off. Ready, set, go. Yeah.
This feels like trying to move a corpse. Okay. Why are we doing this?
Because you're taking over the show while I get dressed.
This feels a whole lot like you just put a bomb on my arm. What? No, I'm not taking over the show. What? What?
Watches are harder to put on other people. You know those guys that steal watches from people with like a smooth move? I'm not that guy. Oh, don't lock it. Don't lock it.
Okay.
Where's the timer now?
I don't know.
It needs to be tighter.
Oh, we'll just cinch it up. Nothing important is going through that arm.
Okay, there we go. Hold that there. This might hurt a little bit. Okay. Now get to the timer by... That's not it. Nope.
You guys, I can't believe you're staying and watching this. I'm so sorry.
Okay, there's the timer.
Okay, Samantha Terry's like, I am out of here.
Okay, there we go.
What?
It's all you. Have a seat.
Are you kidding me right now?
Have a seat.
No.
Sit down.
No.
Sit down.
What? What do you want to talk about? Just saying, you guys, my clothes, I actually can do this because my clothes are in the dryer. I washed them. I did. And then I just left them in the washer. So that's going to be a problem.
Everything you can hear yourself if you talk about that.
I can hear myself think.
Go get dressed. And then watch the burner phone.
What? Are you joking? I'm just going to start pushing buttons. Okay, guys, it's real. He's gone. You guys can just do whatever you want because he's gone. Okay, I have not been watching this. I honestly don't know what's going on. Last I heard, I was walking through the room, and he said something about this is a murder trial and there's citizen's arrest. Is that even what we're doing right now? Is that the trial that we're waiting on a verdict? I have no idea. Also, I'm not sure how to update all of these chats. Jury's hoping for the dinner? Possibly. Yeah, this is our operation right now. We are professionals. We are not professionals. Suddenly, Ari's health monitor notices a rapid increase in heart rate and breathing as I realize he's not joking and gives me the mic. Hi to everybody. Yeah, he's gone. That he's upstairs getting dressed. I don't know how long it's going to take for him to realize that his white shirt is somewhere. I don't know. I don't know if that actually got washed or if it's just still sitting upstairs. I really don't know. It's been a long day. Today, my responsibility, okay, so somebody in our church, a family in the church had somebody pass away. And so I've been trying to I'm supposed to have a dessert ready to go to take to the funeral tomorrow, but I also have somebody else, another friend who had a medical situation that came up on Sunday and has sort of like continued, and so I was busy helping with them yesterday, and I didn't get to the dessert today because on top of that, I received notification as I was speaking with our accountant that we just absolutely need all of our receipts that were a part of building the Airbnb, and I don't have any of those. I don't keep receipts. I don't do that. I don't know how to do that. I swear I'm a minimalist. I burn everything. I throw everything away. And so, but after talking to the accountant, it was like, I don't care what you've done. You have to find those receipts. You have to have evidence of everything that you put into this. And so I've spent the day racking my brains trying to think, where could I possibly find any evidence of what we did? And I did find it, and my son came home and was super helpful because he looked at what I was doing on our Google Doc where we're keeping track of everything and was like, that is a hot mess. And so he came and he cleaned it all up, and it's a much prettier situation. And I think we finally have it all together. So yeah, that's what I did instead of making the dessert. So I do not know what we're going to have for dessert. I am taking ideas now for a quick and easy dessert that I can pull off for a funeral tomorrow. Oh my gosh, been a little stressful. Oh, you guys have so much to say. Yes, you will find them on the credit card statement. This is true. Red Pen, this is how I figured this out. She said just use your credit card statement. And so I'm really good at keeping track of our stuff on YNAB, but I don't have the physical copies of the receipts. So when she said you can just use your credit card receipt, I was able to do a sort using our budgeting software and see all the household expenses, and then I was able to work that backward and go find the information on the credit card. So that's how I did end up finding it, but then I had to cross-reference and say, did I record all of that stuff on our individual stuff? And WeatherWatch, don't call. I don't know how to do that. Hang on. I've seen him do this. That gets plugged in. This gets put some, hang on. Thomas, are you there? Okay, WeatherWatch is here trying to call, but I don't know how. Oh, okay, move.
Okay.
Oh, he says it's live.
It's live. 1 second. We need to go to 3. Okay. Holy cow. Felony trial. We're going to back up right here. Volume on. We'll speed up so we can see something happening.
One, we asked these verdict prior to record.
There we go. Okay. You guys seeing this? Let's go to 3.
Record. It's my understanding that the jurors have reached a verdict. Prior to bringing the jurors in, I want to talk to everyone. We asked these jurors to do a hard job. and to take their time out of their lives. It's a difficult job we ask them. Everyone must maintain the proper decorum. You must keep your emotions in check. If you don't think you can do that, this is the time to leave the courtroom, because I'm not going to tolerate any outbursts or anything else. So if you don't think you can maintain the proper decorum, I'm ask you to leave at this time. With no one leaving, everybody's promised me they'll maintain the proper decorum. Deputy Dexter, if you'll bring the jurors out, please.
I've got under half an hour of deliberation time. Okay, so my shirt, my white shirt, is all wrinkled. I just got it wet and threw it in the dryer because I don't own an iron, and we don't iron clothes. That's yeah, it's not a thing. So my shirt is in the dryer. I'm wearing a hoodie right now, which I'm not gonna wear to dinner. But I got my suit pants on. I think we own an iron, but we never have used it since we moved here in the last 5 years. Thanks, Tina.
Everyone can have a seat. Ms. Barnes, are you the foreperson?
Yes.
It's my understanding the jury has reached a verdict.
Yes, sir.
If you'll hand the verdict form to Deputy Dexter, please.
Deputy Dexter, love that name. Crank the volume just a little bit so we can all hear clearly. No surprises here, I'm sure.
Madam Clerk, you'll publish the verdict.
In the Circuit Court, 14th Judicial Circuit of the State of Florida in and for Bay County, State of Florida versus Jamel Cromartie. Verdict: we, the jury, find as to the defendant, Jamel Cromartie, as follows. Count 1. The defendant is guilty as charged of attempted first-degree premeditated murder. Special findings. We find the defendant actually possessed and discharged a firearm causing great bodily harm. Count 2, the defendant is guilty as charged of tampering with a victim. So say we all, dated this 5th day of December, 2023, foreperson, Michelle Barnes.
Madam Clerk, if you'll poll the jury, please.
Mr. Abramo, is this your verdict? Yep. Ms. Bird, is this your verdict?
And out them.
Mr. Bright, is this your verdict? Ms. Barnes, is this your verdict?
Yes.
Mr. Snyder, is this your verdict? And Miss Behe, is this your verdict?
Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you're at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Ladies and gentlemen, thank you for your service, because that's exactly what you provided to your community today. Other than serving in our country's military, this is the highest calling we have for civilians. Thank you for your service. Make sure you have all of your personal devices and property. Leave your notepads here. Follow the Bay County Sheriff's Office out in the back. They will escort you. Make sure you go back to the other room and get your stuff. They will escort you out of the courthouse. Everyone that's in the courtroom, remain seated and remain in the courtroom till I release you.
Ladies and gentlemen, he'll step this way. Deputy Hines, Deputy Vandal, and Deputy Ford will escort y'all to the other room and get property out in the parking lot of your cars.
They've got one deputy per juror right here, providing safety protection here.
Yeah, he's been locked.
I think just stop talking to him.
It's my understanding, Mr. Sullivan, you have filed a motion.
Yes, Judge, at this time, the state would waive seeking the HVFO and The state's asking to proceed with sentencing.
Williams, is Mr. Cromartie prepared for sentencing?
Just a moment, Your Honor.
He's in cuffs. He's like, I didn't think this day would come. I thought we were going to win. Nope. Lots of bailiffs.
We're prepared, Your Honor.
All right.
Mr. Williams, this is the amended score sheet to what was, that's a call for everything else.
Yes, may I approach? We need time served also.
Yep, it's 1,605 days, 1,605.
Ooh.
Williams, does Mr. Cromartie agree with that?
Yes, Your Honor.
1,605 days.
That's a few years.
I'm going to allow the state to proceed with whatever statements they'd like to make, and then Mr. Williams, I'll allow you and Mr. Cromartie and anybody else who'd like to speak on his behalf.
Honor, as to count one, Mr. Cromartie, with the finding by the jury of the actual possession with discharge causing great bodily harm, faces a minimum mandatory 25 to life on count one. Your Honor, I'm asking for the maximum life sentence on count one. This is the most heinous crimes that you can commit. It is by the grace of God that Mr. Santos shot. He was shot multiple times, as Your Honor heard the testimony. But I would also point out that looking at Mr. Cromartie's score sheet, he has a prior violent felony offense for robbery with a weapon. If you look at the HFO notice that the state filed but is abandoning, that offense, he was released from supervision on that offense in 2016, which was just a short period of time before this offense. Obviously, the conduct escalated in this case, and Mr. Cromartie poses a danger to the community moving forward due to that escalation. Additionally, Your Honor, because count one is a 10-20 life offense, that sentence has to be run consecutive to any non-10-20 life offense, which would be count two in this case. It is a PBL, meaning the maximum is punishable by life. The state is asking for a second consecutive life sentence on count two.
Okay. Mr. Williams.
If I can have just a moment, Your Honor.
Yes, sir.
Okay, I'm gonna have to drop the link in chat because I have to bail. We can't. You guys have to tell me how this ends. So I just put the link of this video in chat. Open that in another window, but at the same time, I'm going to send you somewhere else that isn't there. Does that make sense? Because I'd love to get you guys all over to Dr. Joe Corcoran's channel. So we're going to.
Your Honor, several family members have informed me that they would like to.
We're not going to be able to listen to the family members as they speak. So let me tell you, I've got to run. I've got a date with my wife. She doesn't want to go, but I'm going. I'm dragging her with me. We're going to go have some dinner in a fancy dress. Her fancy dress. I'm just going to be dressed up. I don't wear the dress. I thought I'd make that clear. Anyway, tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again. It'll be tomorrow morning, hopefully with a jury trial with Hannah Payne out of Georgia, hopefully. So you guys let me know how this one ends. I'm thinking there might be a tussle because he seems to be squared off and doesn't want to do what the bailiffs are thinking. So that might be worth watching. The link is right there in chat if you want to watch that and clear it up. Also, I'm going to send you over to Dr. Joe. When you get there, please click the like button. Say some nice things in chat. Give him some encouragement as he's starting off his YouTube channel. He's a great gentleman. I've really enjoyed talking to him, and I still look forward to having him on again. Thank you all. You've been wonderful. Thanks to our amazing mods. You're wonderful as well. We're going to out ourselves from there, and I'm going to go find my shirt, my white shirt, and put on my pickle tie. Maybe I'll even take a picture of how I look for court. So thanks, guys. Be good to each other. We'll see you tomorrow. Bye-bye.